And
Today is the not day of mentioning. Come on Wednesday.
Lordship, I mentioned it yesterday, but unfortunately it is not there in today's list, Lordship. Just an order for service upon the opposite party. That's it, Lordship.
My
My lord, may I?
My lord,
My lord, may I?
My lord,
Yes.
my lord, may I?
my lord,
Kalki mention. Okay.
My lord, may be permitted to mention one matter, my lord. My lord, it's a contempt petition, my lord, and it's a justice of your orders, lordship. It's a violation of your order, lordship.
বলেছেন তো লিস্টে তুলে দিতে আজকেই তো লিস্টে কালকে লিস্টে দিতে নাম্বারটা দেননি they have not given the number.
Lordship, the number was given, Lordship.
No.
I'm giving it once again.
Yesterday.
Yes, yesterday the case number. It was
Yes.
mentioned, Lordship.
You have to mention and give the case number so that the matter is listed.
Procedural, Lordship.
Yes.
My lord, may we, may
sir,
I
I have
permit, my
served
lord,
the notice.
You have served. Yes.
Please.
my lord, may I permit you to mention?
Today is not the day of mentioning, you know, Mr. Agarwal.
My lord, I know, but what has happened that your lordship directed the matter to appear on 23rd. This matter
Yes.
did not appear. That's why, my lord, I have to give the notice. And yesterday only I had to give the notice. Because without notice, your lordship knows I do not mention the matter.
Yes. You serve the notice and come.
I have served. Yesterday I have served the notice. Today I am mentioning, my lord.
Then
And I
come.
was not aware that your lordship will not be taking up today. That's why, my lord, I have given the notice for the day that I shall mention today. This
Mr.
notice
Agarwal,
has already been.
if you want to move it tomorrow, you can move it tomorrow.
No, my lord, it is a motion matter which was directed by your lordship to appear on 23rd. But it did not
23rd.
appear. Yes.
Today, 23rd of what? 23rd. 23rd of?
23rd of May. It did not, in the last occasion, the bench sitting, I mentioned it, but it did not appear. It is not appearing, my lord. This is a motion matter.
23rd, that is means principal bench.
My lord, principal bench.
So what you want now
I want that let it appear as motion.
in the principal bench?
No, here, my lord, here. Because it is a matter
Here.
of Jalpaiguri. Yes, my lord. It is a matter of Jalpaiguri.
Then mention tomorrow so that I can list the matter for hearing.
I have already given notice for today.
Okay, very well. Come on tomorrow then.
My lord.
My lord.
On the basis of this notice, my lord,
It's my matter.
I'll fix the matter.
Oh.
I'll fix it.
Okay.
May I permit to under compelling circumstances regarding item number 42, my lord. In
Today's
this
list.
Today's list. My lord, in this matter, the petitioner has been granted bail on 10th of June 2025.
Very
But, my
good.
lord, due to the excessive bail bond till date, the petitioner could not be released from the jail. If my lord kindly take up the matter today, anytime as your lordship, my lord,
Why anytime? It will be taken up according to the list.
my lord,
So what is the necessary for mentioning?
my lord, because as your lordship yesterday also, my lord, only 12 PM, my lord, the bail matter would be taken up, my lord. My lord, so my lord, if today it could not be taken up, my lord,
Very well, I'll take up this matter.
Lordship may mention.
These are the applications.
the application.
Applications can be taken up. Bail matter will be taken up only to 12.
My lord, yesterday I was sitting 4:30, but my lord, the matter.
Yesterday, the bail matter cannot be taken up after 12. But other matters I have
My
taken.
lord, after bail matter, CRR matter would be taken up. Application is, my lord.
Very well.
Lordship may mention a matter for inclusion in the list. It's an anticipatory bail matter. On the last occasion,
Tomorrow. All tomorrow, no mentioning today.
Lordship.
My lord, may I be permitted to mention one matter, my lord?
No except
it's-
that.
My lord, please, my
Tomorrow,
lord, it's a
tomorrow.
contempt petition.
Tomorrow. Yes, call the list.
Do you mean the number 1? One incident arise in the date of filing, which was written 28 August, in place of 28 February.
Page.
In my lord, it can be on the page 23.
Can petition. Correction for the, what correction you want?
My lord, only date of interest should be calculated from the date of filing. The date of filing was written as 28 August instead of 28 February.
It should be 28 February.
February.
Date of file claim application. And certified copy. You were there at the time of dictation, so why you not mention it?
I have not seen order, one after
All the orders I passed the order in open court.
Did I found the order?
Yes. That is your difficulty.
My lord.
What is the date of filing of the claim application?
My lord, 28,
Where from can I get it?
my lord, in page 23,
Page 23 of
can appease.
can application. Where is the can? Can of what? Can what? Can number?
Can number 1.
Can number 1. Where is can? Can 1. Can 1 is for correction.
Correct. Page numbers, you will see.
This number.
Also the paperwork in 59.
This is the certified copy. Where is the Xerox copy? Where is the Xerox certified copy? Where is the original?
My lord, paperwork, it was mentioned 59. Correct.
Paper book page?
Page 59.
Page 15. Twenty-eighth of February.
Right.
Please take down. This matter appears for correction. At page 3 of order dated 26th of September 2024. At the second paragraph. 1, 2, 3, 4, 5. In the 5th line, the date, the date of filing of claim application should be read as within double inverted comma 28 to 2019 inverted comma close instead of 28/8/2019. Office is directed to correct the same within a fortnight. Full stop.
And smell of family, morning down the class, you get some who create.
Was the direction is already there? What direction?
This amount.
Already direction is there. Next.
Actually, one appeal was allowed on 27/9/2024, Lordship. And subsequently, one correction was also done on 3/10/2024. Now, the Lordship difficulty is that in the order sheet, there is no mention of mode of payment, Lordship. So amount has already been deposited.
How many time you will appear before for correction?
Lordship,
Huh?
before the principal bench, Lordship, I tried, but at that time it was not possible for me.
All correction one time, not several times. You have already one order was passed for correction.
That's what,
Now what you want?
that is with regard to interest, Lordship.
Whatever may be interest.
Lordship,
All correction should be one time. Why the matter
Lordship.
to appear again and again
Lordship.
after disposal soma in there?
Lordship, I apologize, Lordship.
Yes, what you want?
Lordship, actually, mode of payment, actually, there are 3 petitioners, Lordship, in this appeal. But the amount has been deposited, entire amount has been deposited before the register as per the direction of your Lordship. But there is no specific mention regarding the mode of payment, but whether it will be equal or, but so far the direction of the trial court, Lordship, the amount should be in equal basis with interest. But here in this order, there is no mention of mode of payment. Page number 9, Lordship. Order dated 27/9/22.
Yes, only order of modification is there.
Modification, that is 310/2024. More.
No, no.
Lordship, kindly come to page number 9 of the judgment, Lordship. Office of the Insurance Company is directed to deposit the insurance portion as directed above with the Office of the Learned Register, Calcutta High Court, Secretary Jalpaiguri, within a period of 8 weeks from the date of passing of the orders.
So what do you want now? Already direction is there to equal payment by the learned tribunal.
That is the typical learned register. When I appear before the learned register, like to say, so far as this order is concerned, there is no mention whether it will be in equal share or it will not be equal in a different proportion. So
The order of learned tribunal is there.
if it-
Only modification is made regarding the interest.
interest, Lordship.
So every direction of the learned tribunal is there, so
If you
they have to
Lordship
follow that.
If you Lordship kindly record one line
That
regarding
would be otherwise.
as per the direction of the learned tribunal, if it is mentioned, but that will solve the purpose, Lordship.
Only modification is made in respect of the interest.
Lordship.
Then
That
all
has been
order,
done.
all direction is
That
there.
has been done. It is not required, but learned register is saying, no, there is no basic mention.
I am not bothering about the what learned register say.
So for the paper book is concerned, page number 52 is very clear, Lordship.
Okay, please take down. This matter appears under the heading of correction. Learned counsel appearing on behalf of the petitioner. Referred this court in respect of an order dated 27/9/2024, wherein this court has directed the insurance company to deposit the interest portion to the office of the Learned Register General High Court, Calcutta. Learned Register, Calcutta High Court, Circuit Bench at Jalpaiguri. Full stop. This is the contents of the learned counsel for the, this is the contention of the learned advocate for the petitioner that the insurance company has already deposited the amount as directed by this court, but there is no direction for disbursement of the amount in favor of the petitioners, stroke appellants. Having heard the learned counsel for the petitioner, it appears that the order of the learned trial court was modified by the order of this court. In this appeal, all the direction of the learned tribunal was not set aside. Consequent thereto, the registrar, Calcutta High Court, Circuit Bench at Jalpaiguri shall disburse the amount in favor of the appellant according to the direction of the learned tribunal. Let this order be made a part of the order dated 27th September 2020. 27th September 2004.
Deeply grateful, Lord.
But item number 3, my lord, I appear for the petitioner. My lord, may I be permitted to appear virtually, my lord?
Yes, you are there on virtual. How can I?
Lordship. My lord, the offences, my lord, are all magistrate triable. Now, my lord, Lordship would kindly, my lord, take a note
is
of the
there.
date of,
Yes.
You started
my lord, the offences are all magistrate triable. Now, my lord, this FIR was registered on 3rd of June 2023. Now, my lord, prior to registration of this FIR, my lord, there are two title suits, my lord, pending between the petitioner and the de facto complainant. Now, my lord, the first title suit is title suit number 95 of 2022. Now, my lord, it is a suit for declaration, partition, and possession. Now, my lord, Lordship would get the plaint at page 23 of my application. Now, my
Yes.
lord, page 20, Lordship kindly comes to page 23. My lord, Lordship would find, my lord, in that suit, my lord, the petitioner is the defendant number 2.
Yes.
My lord, I am Anwar Hussain. I am the defendant number 2. And my lord, the de facto complainant is the defendant number 19. Sabina Yasmin.
Yes.
Now, my lord, thereafter, there is another suit, which is title suit number 16 of 2023. My lord, this suit was filed on 5th of April 2023. And Lordship would get my WS at page 43. Now, my lord, in this suit, I am the defendant number 2 and the de facto complainant is the plaintiff number 10. Now, my lord, what happens is thereafter, owing to landed property disputes with record of rights, now, my lord, the de facto complainant lodges a complaint before the Block Land and Land Reforms Officer. Now, my lord, thereafter, my lord, she alleges that in course of hearing before the Block Land and Land Reforms Officer, she has come to know that two deeds are forged. Now, my lord, after lodging of this FIR event, she files a third title suit, which is title suit number 28 of 2023. Now, my lord, this suit was filed on 3rd of July 2023, which is just after 1 month of lodging of the FIR. Now, my lord, in this suit also, my lord, the nature of the suit is a suit for declaration and permanent injunction. Lordship would get the plaint at page 55.
Yes.
My lord, in this suit, kindly comes to page 56, which is the cause title of that suit. My lord, Sabina Yasmin is the plaintiff number 1. And I am the defendant number 2. Next page.
Yes.
Now, my lord, even in this suit also, my lord, her allegation is 2 deeds are forged, which she has come to know in course of hearing before the Block Land and Land Reforms Officer. My lord, while filing this suit, Lordship would kindly come to the prayer made in the plaint. What is she praying for? My lord, she does not pray for cancellation of those 2 deeds. My lord, logically, my lord, if I have come to know that 2 deeds have been forged by the accused, I file a suit which is after 1 month of lodging of the FIR, my lord, I should pray for cancellation of those 2 sale deeds. Or at least, my lord, a declaration from the court that the deeds are void ab initio and the deeds are not binding upon me. My lord, no prayer in that title suit. Now, my lord, what happens is before the Block Land and Land Reforms Officer, the Block Land and Land Reforms Officer passes an order. Now, my lord, in the order of the Block Land and Land Reforms Officer also, there is no finding that the 2 deeds are forged. Now, my lord, the Block Land and Land Reforms Officer, my lord, passes an order as against me with regard to correction of the record of rights. Now, my lord, I have preferred a statutory appeal under section 54 of the West Bengal Land Reforms Act before the Block Land and Land Reforms Officer. My lord, that appeal is pending. Now, my lord, in this case, my lord, it's a case based on documentary evidence. My lord, all the deeds have been seized. My lord, investigation is still going on. Charge sheet has not been submitted. my lord, I undertake, my lord, to cooperate with the investigation. My lord, the element of forgery, my lord, she only states before the police authorities, but before the civil courts in her claim, there is no allegation that the deeds are forged. Now, my lord, I shall cooperate with the investigation. Now, my lord, in every suit, my lord, I am contesting each and every suit on merit. I have filed my written statement in answer to every suit. Now, my lord, this FIR has come. My lord, I am praying for anticipatory bail. My lord,
Completely. My lord, in this case, they have filed this title suit only to save the skin of the accused persons. We are not concerned here to regarding the title suit or cancellations deed. My lord, we found that they have procured two forged documents. That's why this is a case of 438. This is not a 438. Initial stage, investigation still going on. We need a custodial interrogations, and we want to root of the who's are the involved.
Whether
Actually,
you have
the
seized the
50
deeds?
time crime, your lordship. Organized crime.
Deeds were seized,
Seized were seized from the BLRO, but the
original deed.
original deed, lordships. No, my lordships. I
Have you served notice?
lordship notice was not served.
Then why not serve the notice?
Lordship, in some cases, his arrest is very much required. Lorships.
Then you serve the notice, ask for the original deeds. What is that doing? Are you? The forgery, allegation of forgery is there,
Lordship.
deeds number is there, and you are not asked the submission of the deeds, which is in the custody of the accused, you know.
They have already preferred the 438 before the district judge, and that has been turned down. And
I
regarding
understand that
aspect-
was turned down.
Yes, lordship.
That is
That's
not
why
the
they are
issue here. Issue is that how the investigation is going on, what is the purpose? Your purpose is to seize the deed first.
Lordship.
Whether you have
That document is already seized.
Whether original deed seized?
Not official.
No, official is not required. The challenge is the forgery, fake documents regarding the seal, emblem, everything has been
Yes.
forged. So
Yes.
you have to seize the original.
But we need a custodial interrogation.
You serve notice first and come. If they are not cooperating, then you can arrest him. That is the issue. You have not proceeded yet.
This is the land of the previously, it was recorded in the land of.
Okay, please take down. This is an application for anticipatory bail. Full stop. Learned counsel for the petitioner submits that there are long-standing dispute between the parties, between the de facto complainant and the petitioner. Consequent thereto, several civil cases are pending before the appropriate court of civil jurisdiction. Full stop. He further submits that the petitioner, being the defendant of those civil suits, are contesting them by filing written statement. He further submits that the allegation made in the complaint in the FIR is false and fictitious. In the suit itself, the de facto complainant stroke plaintiff did not plead for cancellation of alleged deeds. He further submits that the petitioner is ready to cooperate with the investigation. So he prayed for bail in any condition. In any condition. Next paragraph. Learned counsel appearing on behalf of the state raised strong objection and submits that the two deeds are seized. No, certificate copy of two deeds are seized from the office of the block land and land reforms officer concerned. Custodial interrogation of the present petitioner is necessary to unearth the truth. They prayed for rejection of the proposal. Having heard the learned counsel for the parties, considering the nature of alleged offense against the present petitioner, it appears that it appears that the de facto complainant had alleged forgery for creation by creating two deeds. From the complaint itself, it appears that two deeds are registered by the concerned authority. Two deeds are registered by the concerned authority. Full stop. There are always a presumption of correctness of a registered deed. Considering the entire aspect, it appears that the custodial interrogation of the present petitioner non-necessary. Accordingly, in the event of arrest, the petitioner may find bail of rupees 10,000 with two registered securities, subject to satisfaction of learned. Who is there?
learned Chief Judicial Magistrate Coach Bihar.
Learned Chief Judicial Magistrate Coach Bihar, with a condition that he must cooperate the investigating agency in all respect by appearing before the investigating agency once in a week until further order, and he shall abide the conditions laid down under section 438 CRPC.
Grateful, my lord, grateful.
Accordingly, the CRM A Namatali disposed of. Yes, once in a week. In all.
Grateful, my lord, grateful.
Yes.
My lord, I am for the petitioner, my lord. My lord, it's a very unfortunate case and a glaring example how a person has been falsely implicated in this case due to personal enmity. My lord, kindly, first I am saying, my lord, I am a government employee. On that very service, my lord, I was at service. I took 4 classes in college. All the documents are lying with me. I have annexed all the relevant papers and documents. And kindly have a look into the, my lord, first information report made under section 175 subclause 3 of BNSS. That is, my lord, previously 156 subclause 3. My lord, in the first line, my lord, it is stated that আসামির সহিত বাদী স্ত্রীর অবৈধ সম্পর্ক রহিয়াছে. So, my lord, there was a dispute between, my lord, the de facto complainant.
Poxo matter.
Yes,
So
sir,
you have to serve the
Yes,
defect.
sir.
You are appearing for the defect. Service made.
Yes.
Okay.
Yes, sir, service is
Okay,
acceptable.
proceed. Just
Yes, my lord.
the defect was not served. Okay. Yes,
My
proceed.
lord, my lord, first line of the first.
Who submits that he has instruction from his client to not to proceed with this application. Accordingly, the application this is application for what? Application for restoration is considered is disposed of as not present, as dismissed as not present. Next. Who is in the item of 42?
No, I am for the state. No, no, relaxation.
Yes.
Modification of the order, Lordship. Perhaps the bail amount was 50,000.
Yes, who is appearing for the petitioner? You are not. It was mentioned in the first. In the rising, it was mentioned. You are not there at the time rising. You are mentioning this matter. Yes, what is this? What is the application?
Reducing of the bail bond, kindly page number 40.
50,000 with two registered securities like amount. What you want? In a NDPS case, Yes, what is your difficulty?
My lord, petitioner are the day labor and my lord the cultivator. My lord, it is impossible for them to, my lord, pay the amount. My lord, let it be 2,000, my lord.
2,000.
One register, one local man. My lord, they are the day labor and my lord.
Lordship, actually what happened, Lordship?
Then you stay there. Where are you?
Lordship, the coordinate bench granted bail even in commercial quantity, like gaja 30 kilo and that cough syrup to 5 or 6 kilos liters.
Yes.
But so now here, Lordship, 21.7, almost 22 kilo. 20 kilo is the commercial quantity. So he got the bill of commercial quantity. Now he has come to reduce the amount.
My lord, from 4 accused first. My lord, from 4 accused person, 20 kilo.
Whatever may be, bail has already been granted to you. Now
My
you
lord,
are.
they could not be released. My lord, bail granted on 10th of June, my lord. My lord, till date they could not furnish the local shelter. My lord, this is an excessive amount. My lord, let there. My lord, there is a judgment of the Supreme Court. My lord, the bail.
I know that. But local, you want the local.
Fund of the.
You want the registered securities.
No,
Not
Lordship,
local.
he wants the amount to be
No,
reduced.
Surety as because if there is no local surety, they can be played away and there is a no trace. My lord, they let there be local surety, but my lord, the amount to be reduced to 2,000.
2,000.
No, that cannot be considered.
Lordship, from 50,000.
Straight out rejected. 2,000, your prayer is otherwise.
My lord, as your lordship.
No.
My lord, let there be 5,000. My lord, 5,000.
No chance of bargain here.
Lordship, plea bargaining.
They are the cultivator and day labor. My lord, otherwise, my lord, if your lordship direct, my lord, I have to file another.
Arrange for 20,000.
20,000.
20,000. It would be appropriate.
Balance should be there.
Yes.
For the state also.
My lord, let there be then my lord 10,000 local and 10,000.
Now you are.
Otherwise, my lord, if your lordship.
You have started for 2,000.
Fish market.
My lord, what is my instruction? My lord,
If you can arrange 10,000, you can arrange 20,000.
my lord.
Yes, please take down. This is an application for relaxation of condition of bail. Relaxation stroke modification of condition of bail.
Kindly consider.
No, that was straight away rejected. This is not right. Otherwise, if you are able to pay 20,000, I will allow you, otherwise I will reject. That is the only condition. You file a separate application.
Then there will be 20,000, 10,000 local and 10,000 registered. My lord, if your lordship directed 20,000, my lord, learned trial court, my lord, interpret is 20,000 and 20,000. 20,000 registered and 20,000 local, my lord.
This is going on.
20,000, 10,000 local and 10,000 registered.
When the bail amount is mentioned, so it has to be divided. But this code, they take 20,000, 20,000, 40,000.
Why 20,000?
This is going on, Lordship. This is the thing. Lordship, we are facing it.
My lord, here is a 50,000. If I surrender, my lord, I have to pay 50,000.
50,000 local and 50,000.
50,000 with two
With
registered
surety.
like amount.
So the
What
maximum
does it mean? 25 each.
25 each. 130 and 120 it will not be. It will be like on balancing is balancing. Same amount. Same amount.
Bond amount is 50.
50.
So like amount means the
25
should be divided.
My lord,
But they say 50, 50, 1 lakh.
No, that
This
is
goes
not
on.
the correct.
yes, yes.
Lordship, a clear specific order may be passed regarding this. This ambiguity is going on. We have also faced this.
In the Jalpaiguri, not in the Darjeeling, every trial court.
Bond amount is 50,000. This is the not the 1 lakh. 1
That
lakh.
is maximum limit is there, and like amount means equal amount.
Yes.
That's the thing. But they interpret, Lordship. That's the problem going on.
Okay. So I say 20,000 means 10,000.
But my lord, if your lordship direct 20,000, I furnish 20,000, they said that 20,000 local and 20,000 registered. Otherwise, my bill. could
It
not-
becomes 40,000 then.
Very. I'm
Extremely. A clarification may be given on that.
Condition of landed counsel for the petitioner submits that the accused petitioner is day laborer. He could not furnish the bond amount as directed by this court. With the order dated 10th June 2025. He prayed for relaxation of bond amount, considering the submission, learned counsel appearing on behalf of the state, raised strong objects. Considering the submission of the learned counsel for the petitioner, also considering the fact that an order of bail has to be complied with in its true letter and spirit, but at the same time, when an order of bail was granted in favor of a individual, the said order of bail has to be such, has to be on such a condition so that the person may comply with the same. The petitioner has successfully demonstrated before this court his inability to comply with the bond amount as reflected in the order dated 10/6/2020. 10/6/2025. Consequently, the order of bail regarding furnishing bond amount is hereby modified from 50,000 to 20,000. Full stop. I make it clear that the petitioner have to furnish a bond of rupees 10,000 by a registered surety and 10,000 by one local surety. Full stop. On such furnishing of bond, the furnishing of bond as directed herein above is to the satisfaction of learned special court, Jalpaiguri. Special court within bracket NDPS Jalpaiguri. Under the above observation, the application for modification bail is considered and allowed.
Grateful, Lordship.
Next.
Number 43, an application seeking for extension of interim order.
Lord, I am for the opposite party number 2. Lord, Lord, I was directed to file, Lord, the affidavit in opposition. Lord, I am filing it today. Lord, I am serving a copy on my learned friend also. Lord, one thing I would submit. All this stuff. Lord, this matter requires to be tagged with Lord item number 49. Lord, why I am saying Lord? Because I am the de facto complainant in the case. And Lord,
49.
49. Yes, Lord, 49.
Today's list.
Today's list. Lord, I am saying Lord because
Case counter.
That is appearing under heading
criminal motion. Yes. Lord, this matter.
Is the petitioner there?
There, Lord, I am the petitioner.
You are the petitioner there.
Yes, Lord. Case and counter case, Lord.
Today you are in this matter. You are the OP2.
I am the OP2, Lord. Yes.
And you filing the affidavit in opposition.
Yes.
So you don't want to proceed the motion.
Lord, I want Lord that both the matter be tagged together and Lord.
The matter be tagged, so the matter can be heard. Today.
Yes, yes.
So you don't want the motion the matter today.
I want Lord. Right. If it can be heard together, Lord, why I am
saying? If it is to be heard together, then he has to be heard.
Lord, on the question of motion, Lord, let it be heard separately and then it can be tagged after the motion hearing, admission hearing.
Otherwise, both the matter can be tagged together for hearing under the
that can also be done.
Application.
That can also be done. That can also be done.
As you have disclosed your already opposition.
Yes, yes.
So it would be better.
Yes.
Very well. Yes. What is your submission?
I seek extension of the interim order.
One extension. Why extension? What is the date of last date?
For extension and branded copies of service position.
1 week after ensuing summer vacation.
Yes, sir.
Thereafter, it was not extended.
No, thereafter it was not extended. It was filed prior to the expiry of the extension period. It was filed on 23/5/2025.
Tran 4.
Tran 4.
Very good. You are for the state.
Yes, ma'am, I am appealing for this. Madam, in item number 49 also I am appealing for this.
Both the matter I am
Yes,
tagging
yes.
together. Very well. Please take down.
49 এখন 49 টা পরে।
দেখুন CRR
Last time I
373 of 2024. Affidavit in opposition filed on behalf of the opposite party number 2 is taken on record. Full stop. Learned counsel appearing on behalf of the OP number 2 submits that the OP number 2 had already filed and CRR being CRR 291 of 2025.
Lord, one indulgence, parents of the OP number 2.
Parents of OP
the
number
OP
2.
number 2, yes.
Parents of OP number 2 file one CRR being CRR number 291 of 2025, which is running as item number 49 of today's list. He submits that for proper determination of the, this matter, both the instant CRR and the CRR appearing in item number 49 be tagged together. Full stop. You don't have any objection to that?
I do not. But
Okay.
I'm not, I do not have any instructions to appear in that item number 14.
Ask a motion. Lord, motion today only first
Yes.
time appear.
Consider the
Admit of
submission,
it,
let
yes.
both the
কিন্তু tag করে দাও।
revisional application being CRR 373 of 2024 as well as CRR 291 of 2025 be tagged together and fixed for hearing, fixed under the heading of contested hearing, contested application. No, contested, fixed under the heading of hearing, hearing of CRR. Hearing of CRR. আচ্ছা এবার হেডিং করুন CRAN 4 of 2025. This is an application for extension of interim. Learned counsel for the petitioner submits that the interim order was extended lastly on 7th of April 2025 till 1 week after ensuing summer vacation of 2025. Instant if I further submits the instant application was filed prior to the expiration of the period. Expiration of the period. So he prayed for further extension of interim order. Having heard the learned counsel for the petitioner, let the interim order passed by this court on the earlier occasion is further extended. Let the interim order passed by this court on the earlier occasion be further extended till July 30, 2025 or until further whichever is applicable. Let both the revisional application be appear in the list under the heading of hearing on 22nd of July 2025.
22nd কবে? Lord, Lord, let it be next week, Lord, before your lordship. Small matter, both can be disposed of.
Next week,
Next week, Monday,
both matter can
both
be
matter
disposed.
can be disposed of, my lord.
What is the matter? Long matter or short?
No, my lord, short matter. Short matter.
Short matter.
Short matter involved. Very well, I can dispose of.
Both the case diary is lying with me, madam.
Okay, 9th of July.
Grateful.
49th of Corona.
9. হ্যাঁ হ্যাঁ 9 কপি দিয়ে দিলাম কিন্তু সই আবার সই না ওদের কথা বল দুটোই 9
But in this case,
44 I am appealing for this statement.
I am paying for extension of the interim order passed by the honorable court. That is on order dated 30, that is page number 10, my lord. Subsequently, we have mentioned the matter, but that was not listed. And in the meantime, the stay has been vacated.
My lord, it was remain stayed until March 31st of 2025. And the application was filed on
Let me finish.
9th of June 2025.
Obviously.
Not after 3 months of the expiry, my lord.
That is, there is no impediment to file that. I think. Actually, after that, we have mentioned that those matters several occasions, but that was not listed or not touched. Ultimately, we have filed this grant application for extension of the order. We have already served the notice to the both the de facto complaint and the state. This is the affidavit of service.
My lord, interim order is no more, my lord. Already expired up before filing of this application 3 months.
If there is any interim order that any side can be prejudiced. Very good. So. if
We cannot
there is
proceed
a-
with the case,
there
of the
is no
investigation
interim
as per
order,
the
how
order.
can it be extended?
Yes, my lord. Already
So
expired.
you have to file an application for further interim order,
Yes,
not the extension of interim.
yes.
This is the issue. So you have to file CRAN application. What is the prayer in CRAN? Is there any prayer for issuing a fresh order?
No, my lord. Extension of the interim order.
How
How can it be
extend?
possible, my lord? Bracket হয়ে গেছে already. আমরা proceed করতে পারছিলাম না।
Maybe permitted to process this application. Yes, yes. Please take down.
But after completion of hearing, my lord, not pressed.
Plan 1 of 2025 be disposed of as not pressed. Petitioner is at liberty to file the application for interim order. To file a fresh application. File a fresh application for. Next.
My lord, item number 45, I am for the petitioners, my lord. I am appearing virtually. Am I audible? My lord, am I audible?
Yes, you are audible.
My lord,
Yes.
my lord, I am for the petitioners, my lord. This application is appearing under the heading extension of interim order. The interim order was valid till 23rd of June 2025, my lord. It was initially granted on 1st of May 2025. I have served both the opposite parties, the state as well as the de facto complainant.
This was also up to, my lord, June 23rd.
My lord, but the application has been filed prior to the expiry of the interim order on the 18th of June. And it's a very short matter, my lord. My lordship may even fix a date anytime next week, my lord. Otherwise, I'm ready with the matter, my lord. It's a very short point, my lord, involved in this matter.
Have you served upon the opposite parties?
Yes, my lord. The affidavit of service is, my colleague is there, my lord. He's handed over the affidavit of service.
My lord, opposite party number 2.
Yes.
No, no, I'm not the receipt.
Where is opposite party number 2?
State is yet to serve, my lord. State also, my lord, let it be served before in the office of the
So
additional.
it has been served, I believe, my lord.
No, I was in the revision, my lord, but I was not in the CRAN application. It has been served to me. I was
CRAN
the
application
lawyer
has been-
for the state in the CRR, my lord.
Whether copy of CRR has been served?
Copy of CRR has served. Copy of CRR has not been served.
Then
Yes, my lord, it has been served. Kindly sees the order dated 1st of May 2025, my lord. There's a clear reflection in the order, my lord. The first page, the last paragraph. Accordingly, the petitioners are directed to effect service upon the de facto complainant as the state has already been served. We had already served copy of the revisional application on the
It
state.
be a fresh, my lord, service, my lord.
My lord, I may serve afresh, my lord, but let the interim order be extended and let the matter be fixed anytime next week, my lord. The state may be directed to produce the case diary as well, because I'm ready with the matter.
state has already been served.
Yes, my lord, state has already been served.
State has served, not the de facto complainant.
My lord, de facto complainant, the affidavit of service, my lord, I believe it reflects that the de facto complaint has also been served.
Whether the state served the CRR or the I want
CRR
the
has not-
CRR be served.
Here are not been served, my lord. Let it be
My lord,
served.
it has been served. It's given in the order, my lord. It's been served.
No, order is otherwise. The order says that you have served upon the state, not the de facto complainant.
My lord, we have served, my lord, the CRAN application, the affidavit of service, my lord, we have served upon the de facto complainant as well.
Okay, this is the affidavit of service.
Yes, my lord. Kindly sees, my lord, I believe the de facto complaint has also been served.
What is the investment?
There you, okay. Please take down CRAN 1 of 2025. This is an application for an extension of interim order. Landed counsel for the petitioner submits that the interim order was extended till
23rd of June, 2025.
23rd of June 2025. The application for extension of interim order was filed prior to the expiration of the period. Expiration of the period. That is on 18th of June 2025. He prayed for extension of interim order. Affidavit of service filed on behalf of the petitioner is taken on record. Full stop. State is represented. Full stop. It appears from affidavit that the registered consignment was served upon the de facto complainant. Despite full stop. Despite service none appears on behalf of the de facto complainant. Full stop. Considering the situation, the application being CRAN 1 of 2025 is considered and allowed. Let the interim order passed by this court on the earlier occasion further extended till 30th of July 2025 or until further whichever is granted. Full stop. The state is directed. No. Let the matter appear in the list for hearing on 28th of July 2025.
My lord, the matter can be taken up anytime next week because it's a very short matter, my lord.
No, all are short matter. 28th of July 2025 under the heading hearing. Full stop. In the meantime, state shall serve the copy of application CRR 175 of 2025 along with annexures thereof upon the opposite party number 2 de facto complainant and shall submit a report of such service on the service on the adjourned date. Disposed of CRAN application disposed.
Grateful, lord.
Next.
My lord, item number 46, I will appear for the applicant, my lord. Lord, this is the matter under section 482. We have prayed for quashing the FIR and the charge sheet being number 310 under section 341, 323, 325, 307, 506 and 34 of the Indian Penal Code. My lord, there was nothing of land dispute was going on. A title suit was filed, that was being number 54 of 2018, pending since 2018, my lord, in Civil Judge Senior Division, Kuchbihar. Now, my lord, what happened? There was an altercation. There was a counter FIR. My lord, 2 was non-charge sheeted. 8 has been charge sheeted with an ulterior motive. The FIR has been registered, my lord. I'll give a direction, my lord, serve the state and other power. My lord, the charge sheet is appeared in page number 29. That is, we have challenged.
What is your name? Sujon Sarkar.
Yes, my lord. The allegation was, my lord, beaten by wood, batam, iron, but no such thing has been found. It was stated in the charge sheet also.
There are injury reports.
My lord?
There are injury reports collected by the IO during the course of investigation. How this can this case can be quashed?
My lord, at the time of argument,
Yes,
it
at the time of argument, you can demonstrate the matter before the learned magistrate or learned trial court, not before the quashing court.
but my lord, I will lose the forum then.
Yes, you have the forum, but you have to satisfy.
Yes, my lord.
In quashing,
Yes.
the evidence collected by the IO, whether can be evaluated.
No, my
Is
lord.
there any provision? Is there any law to
My lord.
evaluate the?
My lord, not on the evidence, but on the principle of Bhajan Lal, which I was also going
Yes.
to, my lord. The allegations also. My lord, the FIR was made, my submission is the FIR was made an ulterior motive, my lord. There's a counter FIR.
Whatever may be the
Yes.
FIR. But the evidence is there
What is-
collected by the.
What is
Charge sheet has been submitted.
yes, what is
There are some evidence, whether that can be evaluated by a quashing court.
my lord, give a direction
the-
to serve
what-
the state?
Not the serving the state. You just satisfy this court.
Yes, my lord. The
How this court can evaluate the evidence collected by the IO.
my lord, based upon the evidence, the 370.
Have you challenged that the evidence is?
My lord, I have challenged the entire charge sheet hearing, that the evidence is a part of them.
No.
Yes, my lord, kindly come to the
This
first
type
factor.
of quashing cannot be accepted. Never. Show me the provision, at least one provision that a quashing court can evaluate.
What is fallen from your lordship? That is on the evidence part.
Yes, evidence.
Yes,
A single
yes, yes.
evidence is there.
Yes.
That cannot be considered by High Court. It has
Yes.
to be considered by trial court.
That, my lord, that is by the injury report.
Mini trial cannot be done in the High Court in the quashing stage.
Whatever can be done, my lord, within the limited scope under section 482, my lord, what I'm.
Show me the scope.
Yes, my lord, what I want is, my lord, that relying upon that injury report, my lord, what was there? 307 was also been inserted.
Whatever may be 307 may not lie. May not lie. Forget about it.
My lord, each 307, 307, 323 and 325. How can it be, my lord? Section 323 is a simple hurt. 325 is grievous hurt. 307 is attempt to murder. How it can be, my lord?
All cannot be evaluated.
Yes, my lord, kindly. My lord, kindly take kindly come to page number 31 for once, my lord. So nothing has been seized by their part also. I'm not on the trial. I know it sounds like I'm on a trial court, but
Yes.
which I am
Why
not,
you
my
before
lord.
this court?
Yes, no, my lord.
This is a quashing court.
Yes, my lord. Yes, I am before this court under section 482
Only
Yes, there is a limited scope, my lord, but what I want, my lord, even the 12% was there against whom the FIR has been made. The 4 has not been charge sheeted, 8 has been charge sheeted up, relying upon these documents which has been collected by the IO, my lord. Now, my lord, what is my respectful submission is, my lord, no such thing has been shown from the charge sheet itself that the matter was done by my client.
Yes, charge sheet is there.
This is the
Prima facie allegation
this is,
against
my
him
lord,
has been substantiated
my
by
lord, my lord,
collection
my
of
lord,
evidences.
my lord, this is the injury report. What is my lord on? But injury was also something done by
Some other person you are saying, not my client.
Could have.
So that is
Could have.
go
That
to the
is-
trial then,
That is a
not
tri-
before this court.
Yes, my lord, but
I cannot separate these.
Yes,
I
but
court cannot separate
I
these.
want I want to, my lord, ventilate the grievance within the limited scope of 482.
No,
Kindly
no,
give a direction
no.
to serve upon the state. My lord, heard this matter, then if I am unable to satisfy, my lord, kindly reject my application. This matter, my lord, no one will be prejudiced of that. I'm not praying for any stay up to the trial or anything, my lord. Only this much.
That is the reason you are not praying for stay, as because there is no such merit. That's why why the purpose of filing CRR. Having heard the learned counsel for the petitioner, petitioner is directed to serve the copy of CRR upon the state and file an affidavit of service on the returnable date. Let the matter go out of the list, party are liberty to mention.
Grateful, my lord.
Next.
Is again.
This is an application in Quashing of an FIR. Allow the petitioners are the father-in-law and mother-in-law of the complainant. I will kindly looks into the FIR. The entire FIR has named my son. All the
What you want today?
My lord, at this stage, my lord, I'm seeking a stay because, my lord, the entire FIR has been made with a malified intention and is an abuse of process of law. My lord, another accused has approached this honorable court. Another application was filed, and after contested
When the matter was heard on 13th of May,
my lord, at
there
that
is no
moment,
such
my lord,
stay.
the learned honorable court was pleased to direct us to file a supplementary affidavit so
Yes.
that the entire charge sheet could be put on
Where
record.
is the
My lord, that I
supplementary?
have submitted. My
Where is the supplementary?
lord, it was filed in the department.
No supplementary is placed here. No supplementary is here.
Supplementary have been filed with the department. Yeah. My lord, I can. My lord, I can, for my lord's convenience, I can refer to the.
No, I want the original. Where is the supplementary? Have you served the supplementary upon the opposite parties?
My lord, it is at motion stage, my lord. There was no direction to serve upon the opposite parties. Yet.
Okay.
My lord,
So
because
where
there
is the
was.
supplementary? Supplementary. Huh?
It was filed long time back, my lord, in 16th of. Even without the supplementary affidavit, my lord, I can satisfy at this stage, my lord, because the charge sheet has been annexed in the main application itself. And my lord, if my lord goes through the complaint and the charge sheet, it is the reiteration of the written complaint without proper investigation. No independent witnesses has been examined. Under 164, no statements has been recorded. No seizure has been made, my lord. The entire thing has been based on the complainant's version.
Who are you?
I am the father and mother of the husband. That is
Father-in-law and mother-in-law.
mother-in-law. My lord, and in the entire FIR, only vague, general and vague omnibus allegations have been made. You kindly take the FIR, my lord. That is at page number 19 onwards, my lord, of my application.
Paragraph 3, there is a torture, allegation of torture by mother-in-law.
Well, that is a very vague allegation. But what kind of torture? Nothing. Well, kindly looks into this matter. This is a certified copy of the judgment, wherein another petitioner had approached this court. The court has gone into the CD and discussed the allegation, except the husband, everybody else is vague and general. Just to rope it, my lord. This has been done so that they can take advantage of it, my lord. I have my reliance on several judgments passed by the Honorable Supreme Court and these coordinate benches of this court, my lord, wherein this kind of practice in FIR should not be encouraged, my lord. There is no specific allegation. They are just saying, I have instigated that. And that is completely false, my lord.
Who is that in the earlier case?
Earlier case was, my lord, he was a distant relative, my lord. Same FIR. And the investigation completed by the police itself is, my lord, the reiteration of the written complaint without any independent investigation that has been conducted. That is in the charge sheet, certified copy, my lord, at the end. My lord, 2 pages has been given by the police, reiterating the complaint. Without any independent, they have come to a conclusive finding that there is a case. No role of the present petitioners have been found out. No independent witnesses has been examined. No seizure has been made so that any incriminating articles, my lord, there is an 523 has been there, but there is no injury report or any sort of such things on the record, my lord. Because earlier the learned public prosecutor was represented, my lord. My lord, the age of the petitioners are they are aged and ailing, my lord. At this stage, my lord, if they are brought to trial and there is no materials to substantiate the allegations against them. My lord, kindly see the list of witnesses. There is no 164 statement also. So at this stage, my lord, if they are brought into this,
What is the stage of the case?
my lord, charge sheet has been filed. We have come before the court.
Charge sheet has been submitted.
Copy supply is not yet done, but I have obtained a certified copy and approached this court. A limited stay be given, my lord, and in the meantime, I'll serve back.
Petitioners are the father-in-law and mother-in-law of the de facto complainant who lodged a written complaint against the husband and other in-laws, including the petitioners under section 498A, 323, 506 of IPC, which is pending before the learned Chief Judicial Magistrate Jalpaiguri. Learned counsel for the petitioner submits that the investigation of the police is done in perfunctory manner. In result thereof, a concocted charge sheet has been placed. He submits that the allegation in the FIR is general and omnibus against the present petitioners. Moreover, the present petitioners are the aged person. They are not involved in the alleged offense. Thus, they filed the incident CRR for quashing of the FIR, including the charge sheet. Learned counsel for the petitioner further submits that one of the accused of this case, who is a distant relative, filed one application for quashing, which was allowed by this court in CRR number 29 of 2025. Having heard the learned counsel for the petitioner, also considering the charge sheet and FIR, I find substance in the submission of the petitioner. Accordingly, the instant criminal division be admitted. Petitioner is directed to serve upon the opposite parties and file an affidavit of service on the returnable date. Concerning the entire circumstances, further proceeding of GR case number 32794 of 2023, pending before the learned Chief Judicial Magistrate Jalpaiguri, is stayed for a period of 8 weeks from date. Let the matter go out of the list, but is elevated to mention.
47. Oh, 48. Okay, Conditional actually coming to order for under the DPA. In the instance of what happened, the required opposite party.
What is the order you are challenging? Interim maintenance.
Right. She was married earlier, completing this fact, she married with me, and thereafter she filed before the position with her earlier husband, and thereafter she left me.
And you thrown her out?
And then subsisting of marriage, to married me, after marrying me, she filed before the position.
You serve and come. No stay.
Fine.
Okay. Having heard the learned counsel for the petitioner, he is directed to serve the application along with the connector annexures thereof upon the opposite party and file an affidavit of service on the returnable date. Let the matter appear in the list. Let the matter appear in the list in the next available statute. Forty-nine already tagged.
Lord,
43.
only one thing, Lord, direction for service, Lord, if Lordship could add one line that service be effected on the OP number 2. Lord, then we can serve it and the matter can be disposed of on the next day. Without a direction, Lord, then they will not accept service.
Okay, please take down. By an order of this court, this matter 49. By an order of this court, this matter has already been tagged with item number 43 within bracket CRR 373 of 2024. Full stop. The petitioner is directed to serve the CRR along with the annexures thereof upon the opposite party and file
advocate concerned, Lord, that would be easy.
advocate. Okay.
They are already appearing in 43.
State is also there. Okay.
State served, my Lord. I have the copy.
Okay. You want to know? Another learned counsel of the opposite party, learned advocate for the opposite parties. Let the matter appear along with the CRR 373 on the agenda.
Great. I can have a motion.
373 2024. No. Next.
48.
48.
Oh, 49.
Vishwanath, কি করছো?
50. Lord, I am for the petition. My Lord, the matter is in the motion stage. Inadvertently, my Lord, my law clerk has served it in advance upon the state, so my Lord, state is appeared. My Lord, the matter is very short. My Lord, in 2019, my Lord, the OP number 2 had advanced me a loan of rupees 40 lakhs. My Lord, a friendly loan without any interest to be repaid within a span of 20 years. My Lord, for setting up a new business. My Lord, I have accepted the loan, use that money for establishing my new business. My Lord, there is a loan agreement to that effect. Page 38, my Lord. Kindly, once, my Lord, page 38. It starts from operative part, starts from page 41.
$40 lakhs.
40 lakhs. Page 41, my Lord. Lordship will find the clause 2 in the bottom part. first party has paid a sum of rupees 40 lakhs only to the second party through check number so and so. And my lord, third, the second party will pay the borrowed amount of 40 lakhs only at 0% interest to the first party in the period of 20 years. So, my lord, this was the agreement. I have received the money, used that money for starting my business. Now, my lord, though the period of repayment was 20 years, but my lord, within 1.5 years, my lord, I have already paid 10 lakhs. Now, my lord, in the year of 2023, my lord, a complaint has been lodged by the de facto complainant, my lord, who is the OP number 2 and who has advanced me the loan, that he had paid me a sum of 2 crores for purchase of land. And there was an agreement of 2 crores and he has already paid me 1.6 crores for purchase of land. But after receiving the money, I am not handing him over the land or not executing the deed of sale. Lord, all of a sudden, after receiving this, Lord, after lodgement of this complaint, Lord, I preferred an anticipatory bail application before this honorable court. Lord, I was granted anticipatory bail. Lord, thereafter, Lord, I issue a legal notice to him. Lord, saying that if since you have alleged payment of rupees 1.6 year, you are directed to put a strict proof of the payment. Lord, investigation, Lord, has been completed. A charge sheet, a purported charge sheet has been filed. Lord, astonishingly in the charge sheet also, there is no proof of payment. Lord, because there was no payment at all. 1.6 crore, Lord, cannot be paid in cash. In the FIR also, Lord, they do not say anything about the mode of payment. And Lord, without anything, Lord, a charge sheet has been filed. Lord, I have received the 207 papers, only few 161 statements saying that Mr. So and so has paid a sum of rupees 1.6 crores. How, when, Lord, nothing. And Lord, on the basis of these materials, Lord, I am supposed to face the trial. Lord, moreover, one more thing. The charge sheet has been filed under section 406 and 420 of the Indian Penal Code. Milord knows 406 and 420 Milord are antithetical to each other. Milord cannot coexist together. So, Milord, under such circumstances, Milord, I am praying for a stay. Milord, I will serve and come back, Milord. And thereafter the matter.
I am for the state, my lord.
Yes.
So for the documents filed by the.
Only one thing I would say, Milord, this is a motion stage matter, Milord.
You have served the copy
That
to.
is an inadvertent error on my part.
Whatever maybe as he is here, it is the
No, Milord,
opportunity.
Yes, Lordships. And moreover, Lordships, this is the case. The amount has been paid. And another plea taken by our friend that 406 and 420 cannot run together. It is true. But at this stage, charge sheet has been filed. There is a scope for the charge, framing of charge. And so for the other concern, 161 statement and other concerns, at this stage, it is not possible to ascertain whether they how the way they paid the amount 2 crores. Definitely, some original CD is very much required for the ascertain. So at this stage, without stay, serve the copy to the de facto complaint also. Maybe they don't have the documents.
Very well. Please take down. Instant CRR has been preferred for quashing a proceeding being GR case number. What is the GR case?
Lordship, GR case number. Matigara PS case number.
I know the Matigara case. What is the
PS case number, my lord. GR case.
591 of
2023. Matigara case.
that is Matigara PS. GR, what is the GR case? Charge sheet number is there. ছাড়ো দেখো কি বললাম causing a criminal proceeding initiated through Matigara police station case number
591 lordship
591 of 2023 dated
25th July 23
dated 25/7/2023 under section 406 420 34 IPC wherein a charge sheet has been submitted being charge sheet number 479 of 2024 dated 30 9/2024. Now pending before the learned SEJM Siliguri. Full stop. Learned counsel for the petitioner submits that the there is a submits that there is a loan agreement between the petitioner and
Actually, GR number I have 2702. 2702/23.
702/23.
Yeah.
Criminal
case number.
proceeding being GR case number. Criminal proceeding being GR case number 2703.
2702/2702.
2702 of 23.
Yes, Lordship.
Says arising out of Matigada case case. ঠিক আছে বললাম বল there is a loan agreement between the petitioner and de facto complainant by which the de facto complainant has advanced a loan of rupees 40 lakh with zero interest, with 0% interest, supposed to be remitted within a period of 20 years. Subsequently, no, the petitioner has received the loan amount according to the agreement. Subsequently, the instant FIR was lodged in an ulterior motive. He submits that in the FIR, it has been alleged that total consideration money of 2 crore has been received by the petitioner, but no mode of payment has been disclosed in the FIR. The police has conducted a charge sheet and conducted investigation, and it was made in a perfunctory manner. The investigating agency, without receiving any evidence of mode of payment of such huge amount, has submitted the charge sheet. So we prayed for admission of the instant criminal division, and at this stage, the stay of further criminal proceeding. Learned state advocate appears and raised strong objection and submitted that the investigation of the policy generating charge sheet full stop. During the course of investigation, the available witnesses were examined, their statements were recorded, documents were collected, and the basis of that, the on the basis of that, the prima facie allegation is the present petitioner has been substantially proved, on the basis of which the charge sheet has been submitted under section 406, 420/34 IPC. At this juncture, without service upon the de facto complaint, no order of stay can be passed. Having heard the learned counsel from the parties, considering the materials, also considering the charge sheet, also considering the copy of charge sheet and the FIR, it appears that the IO has not collected any document in respect of receiving of huge amount of money by the petitioner. Only IO has collected some evidence of oral witnesses and recorded their statement under section 160. Considering the same, I find there are substance in the instant criminal division. According to the instant CRR be admitted. Petitioner is likely to serve the private opposite party and file an affidavit of service on the returnable date. Let there be an order of stay of further proceeding of GR case number 2702 of 2023, pending before the learned SEJM Siliguri till a period of 8 weeks from date. Let the matter go out of the list, party early mention.
Highly appreciated. Highly grateful.
51. Well, I am for the petition. Well, petitioner number 1 and 2, they are husband and wife. Well, the OP number 2, Lord, the de facto complainant. Lord, he is the brother of the petitioner number 1 and brother-in-law of the petitioner number 2. Now, Lord, there was a family business, Lord, of a wood sawmill, Lord. And Lord, after the death of the father of the petitioner and the OP number 2, Lord, the family business, Lord, has been inherited by both the sons. Now, Lord, since the petitioner number 1, Lord, is a government teacher, Lord, he relinquishes his right from the business and Lord, gives a NOC to his wife, who is the petitioner number 2, to enter into a partnership arrangement with the OP number 2. Now, Lord, both petitioner number 2 and the OP number 2, Lord, they enters into a partnership and inherits the business of the father. Lord, the business started in the year 2021 in the new partnership arrangement, and thereafter, Lord, some disputes occurred with respect to Lord, functioning of the partnership. Lord, the OP number 2, Lord, he at his own whims and fancies, Lord, he did not share any accounts, anything, Lord, with the petitioner number 2, and consequently, Lord, the dispute came till 2024. Lord, in the meantime, the petitioner number 2, Lord, preferred complaints before the DFO, Lord, for not providing the accounts, the business details, and so etc. etc. Lord, what the DFO did, Lord, he suspended the license of the forest license. And Lord, consequently, the operations of the sawmill, Lord, was closed down. Lord, after all this happening, Lord, the petitioner number 2, OP number 2, files this present complaint, saying that my brother, who is the petitioner number 1, executed a deed of gift to me, thereby transferring a land in the year 2021. But actually, it was not a gift; it was a sale, because I have paid rupees 50 lakhs to my brother for transfer of the land. But since he has executed a deed of gift, Lord, he has caused loss to the government to the tune of rupees 70,000. And as such, Lord, this complaint has been preferred. And Lord, astonishingly, based on this complaint, Lord, section 409 of the IPC has been leveled by the police, saying that he is a government servant. Lord knows when a public servant in official course of his public duties, Lord, commits a breach of trust, Lord, only in that even 409 is applicable. Lord, so far as the complaint is concerned, Lord, this only says that I have Lord, cheated the government a revenue of 70,000 by executing a deed of gift instead of a deed of sale. Now, Lord, I put this question to myself. When a deed of sale is executed, Lord, who is the person responsible for paying the government revenue, Lord? The purchaser, the person who is accepting the sale. Lord, he is the person who needs to pay the registration fees, the stamp duty, etc., government charges. So, Lord, even if that is accepted to be true, Lord, it is the OP number 2 who had to pay that 70,000 rupees. Lord, I preferred an anticipatory bail application before the learned sessions judge. Lord, may kindly take up Lord, page number 44 once. What was the submission of the learned state advocate, learned public prosecutor during that process? Page 44. Page 44, Lord. Lord, 5th paragraph, just before heard both sides. On the other hand, Lord, it starts from. On the other hand, learned public prosecutor Jalpaiguri raises objection, but has been candid to submit that government has not suffered any loss of revenue. Lord, based on this, Lord, I was granted anticipatory. Lord, I am before your Lordship, Lord, at present, Lord, only stay of proceedings. Lord, I will serve and I will come back. Lord, the complaint itself is not maintainable. Lord, given the set of allegations, Lord, the police cannot initiate a FIR on the basis of this term.
Please take down. This is an application for quashing of an FIR dated 4/3/2025, being Jalpaiguri PS case number 122 of 2025, dated 4/3/2025 under section such and such of BNS, pending before the learned CGM Jalpaiguri. Learned counsel for the petitioner submits that the allegation in the FIR is false and concocted. It has been alleged in the FIR by the de facto complainant that the present petitioners has caused loss to the government exchequer by making a deed of gift while it is actually is a deed of sale. It appears, full stop, it appears that the FIR itself disclosed that the de facto complainant is the transferee of the said deed, whether it is deed of gift or deed of sale. The transferee has the liability to pay the stamp duty to the government. Considering the same, the instant CRR be admitted, petition is directed to serve upon the opposite parties and file an affidavit of service on the returnable date. Concerning the entire aspect, let there be order of stay of further proceeding of the criminal case of the criminal proceeding being criminal proceeding arising out of Matigada PS case number 120, Moinagudi PS case number 122 of 2025 till a period of 8 weeks from this. Let the matter go out of the list, particularly to this. Next. Learned counsel appearing on behalf of the petitioner on instruction. Intend to withdraw the matter. Withdraw the instant application. Accordingly, the instant application be disposed of as not placed. Actually, that's all. Supplementary. Supplementary final. Okay. Order for it. Okay. If bail matter up to 1, then there will be no matters. One matter can be done after all the matters. The bail matter can be taken if time permits. If time permits, otherwise other matters cannot be taken out.
All the determination in this event, it is box, complete category, only other matter, code number, all the concept.
Lordship, it can be 12:30 till.
Very good, 12:30. 12:30 করে দেবো।
Obliged.
List. Okay.
আপনার এখানে একবার ক্যামেরা নিয়ে পুরস্কার ইচ্ছা করি
একদম যাবে মানে মুখটা ধরে আমি দেখেছি তোরা এইদিকে এই যে সেদিন যে ম্যাটারটা করলাম না আমি তীর্থদার ঘরে ওই যে সিসিটিভি ফুটেজ চেয়েছিল সিআরআরটা বললাম দিতে পারছে না অর্ডার তো হয়ে গেল ইন্টারপ্রিটেশনটা ওরা বলছে তীর্থদার অর্ডারে স্পেসিফিক্যালি বলেছে এই প্যারাগ্রাফটা পড়লেই বুঝতে পারবে যেটা অনকোট ইয়ে করলো আমরা রিপোর্ট দিয়ে বললাম যে সিসিটিভি ফুটেজ আমাদের কাছে নেই তারপর আমরা নিই নেওয়ার কোনো মানে নেই তারপরে 2 মাসের আমাদের কাছে অ্যাভেলেবল ইয়ে করলো এটা 2 মাসের আগের হতো না কিন্তু আমরা নিই তীর্থদার এমএসসি অর্ডার করলো লোয়ার কোর্টে আপনি অর্ডার নিয়ে গেছে লোয়ার কোর্টে বলছে তুমি আমাকে সিসিটিভি ফুটেজ দাও আর তুমি ইয়ে করো, সেটা যেটা তুমি ইয়ে করেছো, কালেক্ট করেছো সেটা দাও। কালেক্ট আমরা করি, এবার ওটা ওরা দাঁড়ান, ওরা ওটা বুঝতে পারছে, ওরা অর্ডারে রিফ্লেকশন করে বলছে সিসিটিভি ফুটেজ এই অর্ডারটার সঙ্গে, ঠিক আছে। আমি বললাম এই অ্যাম্বিগুইটি যখন হচ্ছে তখন আয়ও একটা এফিডেভিট করে বলে দেবে শেষ পর্যন্ত ম্যাটার ওদেরকে কপি একটা সার্ভিস করতে বলেছিল, যেটা অর্ডার করি সঙ্গে সঙ্গে আমরা সেটা কপি, যেটা আমরা ইয়েটা দিয়েছিলাম সেটা আমরা দিয়েও দিয়েছিলাম, পিটিশনকে দিয়েও দিয়েছিলাম। যদি আমরা কিছু সিজ করি তখন লোয়ার কোর্ট বলেছে যে ওটা একটা অ্যাপ্লিকেশন করবে, সেই অ্যাপ্লিকেশনটা অ্যালাউ করবে, তারপরে ওটা পিটিশনারকে সিসিটিভি ফুটেজটা দেখতে দেবে, ঠিক আছে। সিসিটিভি ফুটেজই নেই, আমরা সেই অর্ডার যে এখানে দিলাম, এখানে ডিসপোজ অফ করে দিল, সেটা যখন আমরা লোয়ার কোর্টকে দিচ্ছি, বলছে তুমি আমাকে না, এটা হাইকোর্টের অর্ডার ভ্যালিড ইয়ে হয়ে যাচ্ছে, ঠিক আছে। এবার আমি তখন বললাম অর্ডারটা এটা পর, আমি বললাম যে একটা আয়োকে একটা ইয়ে করে দিয়ে দিতে, তোর এফিডেভিট করে বলে দিতে, তাহলে এটা এফিডেভিট থাকবে।
রিপোর্ট পাঠানো হয়েছিল, উনি ওটা এক্সেপ্ট করেনি,
আমরা এই মধ্যে সিসিটিভি দিতে পারবো।
CCTV footage which has been collected by the concerned SRE.
What is it?
লিখেছো তো already.
অ্যাম্বিগুইটিটা কি হচ্ছে, অর্ডারটা আমরা অর্ডার তো বলে দিয়েছি সিসিটিভি ফুটেজ আমরা কালেক্ট করলাম না, এটা বললাম এটা এডিট করে বলে দিতে বললাম। রিপোর্টটা তো একটা কোর্টকে দেওয়া হয়েছে, আর এটা আমাদের কাছে কপি আছে।
রিপোর্টে দেখুন কি বলেছেন এই সংক্রান্ত।
ওই যে এটাই বলেছে রিপোর্টে, ওটাই বলেছে যে আমাদের কাছে 2 মাসের ইয়ে আছে, তার জন্য আমরা
ওই 2 মাস সাথে দিতে হবে।
না না, পরের 2 মাসের দিবি কেন? পরের 2 মাসের
আগে 2 মাস,
হ্যাঁ
এই যে রিপোর্টটা এখানে পড়বে।
আগে 2 মাস তো, আগে 2 মাস তো
এখানে বলে CCTV which has been collected, যেমন 2 মাসের আগে আগে আছে, এই 2 মাস শুধু
সেটা কালেক্ট করে দিই, সেটা কালেক্ট করে দিই, সেটা কালেক্ট করে 2 মাসেরই থাক, আর আজকের থেকে 2 মাস
সার্টিফাই করা হয়েছিল আমাকে। আমি যখন রেলকে প্রেয়ার করি, রেল আমাকে এটা সার্টিফাই করে দিয়েছে,
ওটা এডিট করে বলে দিতে, রিলিজ করে বলে দিতে। তারপরে রেজিস্ট্রেশন লোয়ার কোর্টকে
is available up to 20th April 2015
স্পেসিফিক বলে দিই,
এটা
হাইকোর্ট জানে,
এটাই নিয়ে দিতে হবে।
আর ওইটাই তো কোর্ট বুঝতে পারছে না, সেটাই তো কোর্ট বুঝতে পারছে না, বুঝতে পারছি তো, এই রিপোর্টে তো কোর্ট বুঝতে পারছে না। এবার আপনাকে যেটা করতে হবে সেটা হচ্ছে কি, ওটাকে ভেঙে আরো আপনি এফিডেভিট করে বলে দিন, ওই অ্যাম্বিগুইটি যেটা হাইকোর্ট অর্ডারের মধ্যে কোর্ট বুঝতে পারছেন না, আপনি এফিডেভিট করে বলে দিন, ওখানে একটা এফিডেভিট একটা তৈরি করে দিন, ওটা লোয়ার কোর্টকে পিপিকে দিয়ে ওই এফিডেভিটটা সাবমিট করলাম। এটা আমাদের এখানে কিছু করার নেই, কোর্ট কি মনে করছে ইংরেজি করে যদি অন্য মানে বলে ছেড়ে দেবো, এটা ডিসপোজ অফ হয়ে গেছে, এখানে আমাদের কোনো জায়গা নেই।
প্রেয়ার করেছেন, প্রেয়ার ভিত্তিতে এই সার্টিফিকেটটা করেছে।
এই যে আছে তো अवेलेबल আছে 20th এপ্রিল থেকে 19 জুন পর্যন্ত।
কিন্তু সেটা আপনি তো আমরা অন কোড করলাম, ওটা নিয়ে তো কোনো লাভ হবে না, কারণ ওটা তো ঘটনা কি করছে না,
তাই আমরা এটা
কারেক্ট করছি। হ্যাঁ, সেটা আপনি এফিডেভিট করে বলে দিন,
সেটাই আপনাকে বলতে হবে যে আমাদের কাছে যে আমি এনজিপির কাছ থেকে যেটা নিয়েছি সেটা এইখান থেকে লাস্ট 2 মাসের পর থেকে ওটা ডিলিট হয়ে যায়, ওটা থাকে না। শুধু 2 মাসেরটা আমাদের নেই, আমাদের কাছে এইটাই আছে। এইটাই করে
সাবমিশন না, এইটা এক্স্যাক্টলি এইটা মুখে সাবমিশন না, আপনি যেটা কোড বুঝতে পারছেন এটা আপনি এফিডেভিট করে বলে দিন, এই কথাটা হাইকোর্ট অর্ডারকে ডিলিট করে আপনি এফিডেভিট করে বলে দিন।
এই যে আমাদের লোয়ার কোর্ট যেটা করেছে স্যার, এই অর্ডারটা করেছে আগামীকাল।
স্যার একটু কথা বলুন স্যার।
হ্যাঁ, ওই অর্ডারটাতে ওই জায়গাটাতে কনফিউশন হয়ে আছে,
যেটা অ্যাভেলেবল আছে ওই পর্যন্ত আমরা ওটা কালেক্ট করতে দিই, সেটা কালেক্ট দিয়ে
তাই তো দিতে হবে, আমরা এটাই কালেক্ট করেছি, কারণ আমাদের বলেছে আগে 2 মাসটা
রিপোর্ট করে
রিপোর্টটা কোথায় আপনার, সেটা কি চাইলাম আমি।
এটা রিপোর্ট আমরা করছি, আপনি একটা স্নাপ
সফট কপি আমাকে দিন, ওটা সেটা হার্ড কপি নিয়ে আমরা থাকবে
সেই রিপোর্টে যদি হার্ড কপি চলে গেছে,
বেশ তো সফট কপি একটা হার্ড কপি করে দিন না, সফট কপি একটা হার্ড কপি করে দিন না, তাহলে হয়ে গেল। ওনার সঙ্গে কথা বলুন, পুরো দেখে নেওয়া এটাই ইয়ে ওটা করে নিন, তারপর
আপনি রিপোর্টটা কি দিয়েছেন সেটাকে দেখি।
হ্যাঁ সফট কপিটা যেটা আছে হার্ড কপি পে করে স্যার,
কারণ এখানে যখন বলেছে
রিপোর্টটা সব, রিপোর্টটা তো আমি আবার অ্যাপ্লাই করেছিলাম, রিপোর্টটা ওটাই ছিল যে সিসিটিভি ফুটেজটা অ্যাভেলেবল নয়, ঠিক আছে, আর ওই সময় ওই দিক থেকে দেওয়া যাবে
কিন্তু এখানে অর্ডারটা কিন্তু সম্পূর্ণ অন্য।
সম্পূর্ণ অন্য তো
Which
এবার
has been collected by the concerned ISI.
কিছু ক্যালেন্ডার কালেক্ট করা হয়
এই অর্ডারের মধ্যে তো আছেই, এখন তো করতে চাপবেই, এখন তো আসবে তাহলে।
হ্যালো, হ্যাঁ নমস্কার। আমি ব্যাপারটা জানি, ব্যাপারটা হচ্ছে ওনার সঙ্গে কালকের থেকে কথা হচ্ছে। ব্যাপারটা হচ্ছে কি, যে অ্যাম্বিগুইটি থাকছে না, ওই জায়গাটাকে ক্লারিফাই করতে হবে, একটা এফিডেভিট করে বলে দিতে হবে। আমরা হাইকোর্টে আগের দিন যেটা সাবমিশন করেছিলাম, ওই রিপোর্টটা দিয়ে এবং টোটাল ব্যাপারটা ডিসপোজ অফ হয়েছে। কোর্ট যেটা লিখছে যে যদি সিসিটিভি ফুটেজ, আর আলটিমেটলি সিসিটিভি ফুটেজটা তো আমাদের মানে নেওয়ার কোনো দরকারই নেই বা আমাদের কোনো অবকাশই নেই। তার কারণ হচ্ছে কি, লাস্ট পিরিয়ড 2 মান্থস ওটা অ্যাভেলেবেল ছিল। হ্যাঁ হ্যাঁ হ্যাঁ, কারেক্ট কারেক্ট। সো সেই জায়গাটা এক্স্যাক্টলি সেটা আমরা সেটা হাইকোর্টকে বলেও দিয়েছি। এবার সেই বয়ানে যদি কোনো অ্যাম্বিগুইটি কিছু হয় না, তাহলে এটা আইওপি দিয়ে একটা এফিডেভিট করে দিই টোটাল ব্যাপারটা, মানে হাইকোর্টে সেদিন যেটা হয়েছে এবং টোটাল হাইকোর্ট যেটা অর্ডার দিয়েছে, তাহলে কোনো অ্যাম্বিগুইটিতে থাকবে না। এটা ওর দিয়ে এইখানেই করবে, মানে মানে আপনি রেডি করে দিয়ে লোয়ার কোর্টে ওটা দেবে, লোয়ার কোর্টে পিপিকে দিয়ে ওটা এফিডেভিটটা দিয়ে দিবে, তাহলেই অ্যাম্বিগুইটি কিছু থাকবে না। তারপরে কোর্ট যদি কিছু অ্যাকসেপ্ট না করে, তাহলে ওর যা অর্ডার করলো সেটা রিজিস্টার আমরা তখন সিআরএল চলে আসবে। ঠিক আছে, এটাই একমাত্র উপায়। আরে আমরা তো করতে পারছি না ওই জন্য, অর্ডার যদি এখানে রিফ্লেকশন ওটা আসে, তাই অ্যাম্বিগুইটিটা আসছে। আপনারা টোটালটা দিলাম, যেটা বলছি টোটাল যদি আগে যেটা হয়েছে এবং কোর্ট অর্ডারের বেসিস অলরেডি ওটা সাবমিশন করে দেওয়া হয়েছে, টোটালটা দিয়ে লোয়ার কোর্টকে একটা এফিডেভিট করে বলে দিলাম, ম্যাক্সিমাম ওটা বলে দিলাম। এবার ওইটাই ওরা অ্যাকসেপ্ট করবে, যদি অ্যাকসেপ্ট না করে সেক্ষেত্রে আমরা এই অর্ডারটা বেসিস তখন আমরা আসবো। অ্যাকসেপ্ট করুন, না করুন তখন আমরা আসবো, কি তাই তো?
বিষয়টা কিন্তু আমি আবার বলছি, একটা জায়গায় কিন্তু আছে রাজনীতি, যেটা কিন্তু ঝামেলা করবে। আমরা যদি আবারও করে আসি, আমরা কিন্তু ফিরে যাবো।
কেসটা হচ্ছে
টিকফুলার অর্ডারে অর্ডারটা এই টিকফুলার অর্ডারটা
এই যে যেটা কথা বলছিস তো, হাইকোর্টের অর্ডারটা এটা এখানে আসবে।
CCTV footage which has been collected already আমি কালেক্ট করে নিয়েছি
by the
concerned SI
police
is immediate special court এবং
এটাই বলছি তাই তো, এটাই বলে দিচ্ছি।
তারা ওর কাছে এটা কালেক্ট করা আসে, সেটাই রিপোর্টে নিশ্চয়ই ছিল না, কি করে কথা হয় তার এই কলর কি করে আসছিল না রিপোর্টে রিপোর্টে আছে। হ্যাঁ আছে, এটা আসলে এটাকে আবার মডিফিকেশন করতে যাও মানে ইয়ে করতে হবে। রিপোর্টটা দেখো, রিপোর্টে বলা আছে
আমি তো সেটাই বলছি, ঘুরিয়ে বলছি। আমি বলছি কি, আমি এইটাকে আমি কোর্ট করে বলে দেবো। কোনটা রিপোর্টের সার্টিফিকেট রিপোর্টটা আছে,
এটা রিপোর্ট দেওয়া ছিল এখানে বল স্টোরি।
আরে রিপোর্টের সার্টিফিকেট কোর্ট তো বিকেশ রিপোর্টের সার্টিফিকেট কোনো তোলার দরকার নেই, কারণ কি রিপোর্টটা যখন আমি দিলাম, সেই রিপোর্টটা কোর্ট বললো যে তুমি আসতে কোর্স অফটারে তুমি পিটিশনারকে একটা কপি দিয়ে দাও। আমরা পিটিশনারকে কপি দিলাম, পিটিশনার তো এটা চাইছে না, পিটিশনার তো নিজেও
এই লাইনটা যেখানে লেখা আছে না, কিন্তু ট্রায়াল করতে বুঝি না, ট্রায়াল করতে
সেটা এডিটিং করে বলতে দিতে সেটা
আমরা বলেছিলাম যে এর মধ্যে আপনি কারেক্ট করেনি, কিন্তু কোন ভুল করেছে।
ইয়েস, আমি এডিট করে বলে দেবো যে অর্ডারটা আমাকে তার দায়িত্ব নেই, ওখানে আমি এডিট করে বলে দেবো যে এডিটিং একসেপ্ট না করে বক কমিশন করছি, যদি না করে তখন আমি ইয়ে করবো, তখন আমি ইয়েস তখন আমি ঘুরে আসবো। এখন আমি ঘুরে আসবো, অর্ডার নিয়ে আমি এখন ঘুরে আসবো না। ঠিক আছে, আপনি এডিট করে, যেটা আমি বললাম এডিট করে বলুন, বললে পরে কোর্ট যদি মেনে নিল দেখ সকালে এডিট করে আমি বলবো এটাই রেকর্ড। কোর্ট যদি না মানে তখন আপনি আসুন, তখন আমি বলবো ওই অর্ডারটা চ্যালেঞ্জ করি।
Before that, no copy. I could have already first page. First page then Sufi কি বলা আছে?
Mr. Chakraborty Lani appearing to the state established that a report has been prepared by the Southern State of Police attached to Newcoastal Place. The same includes the contains regarding the parking area of Newcoastal railway station, platform number 1 and 3 at Newcoastal railway station of full overreach of Newcoastal railway station on 12/25 in respect of different timings and division. We need to ask you that report has been prepared by the Southern Inspector of Police. বুঝতে পারছি এখন একটা রিস্ট্রিকশন হয়ে গেছে এখন হাইকোর্টের অর্ডার রিস্ট্রিকশনের তো হাইকোর্ট চাইলে আপনি আসুন রিপোর্ট নিয়ে আসুন বাইরে
আপনাকে যেটা দেওয়া হয়েছিল
হ্যাঁ ওখান থেকে লেখা বার করেন
কোথায় গেল তিনে আপনি দিকে মারা আমার এখানে ফাইলগুলো নম্বর রিপোর্ট পাঠিয়েছি কপিটা এটা লাগাবো এখান থেকে লাগাবো দা লার্নেড পিপি এখানে কোথা থেকে লাগাবো এগুলোকে আমাদের কোন কোন করে নাম আছে ক্লাস সাইজের বা এসে নেবে যাচ্ছে তারপরে লিখে আই তুমি ডকুমেন্টে সাকসো ডেট অফ পোস্ট করতে এই শুধুমাত্র পুরি নাম পুলিশ স্টাডি বলে তুমি বলেন আমি যা বলে এখন বলছি আমি যা বলা কিন্তু এখন এটা এখন বুঝে যাবে আমাকে কি বলে করুন জানো না
ওহো কি ওটা ঢুকি না তখন আমার কি থেকে এটা অ্যাড্রেস করো তুমি তাহলে আর দিন বলো কি করে দাও কি ভিডিও দাও ভিডিও দাও তো না কি করো বিয়ে লাগছে তাহলে কি টেস্ট দিয়ে দিতো 19 তারিখ দেখো আইটি নিয়ে যা কখন শুরু এবার রিপোর্ট ডিটেইল সিসিটিভি বলেছে কথা কেলা না আপনি দেখতে শুনে আমি কনসার্ন করে সেটা মনে দিত তো দেখতে হয় দিকে দেবই না সেটা বাড়ি সেটা দেবই না ব্যাগ আমার কাছে দেখলাম যেহেতু যেহেতু আমার পার্টি করতে আমি যেটা করতে পারবো আমি আলাদা মানে ট্রেনিং করবে একটা হচ্ছে যেটা আলাদা আলাদা ঠিক করে দিতে হবে এটা আছে না ওখানে কোর্টে যেটা দেওয়া আছে মানে হ্যাঁ কোর্টে দেওয়া আছে ওটা ওটা নেই
একই তো কন্টেন্ট আছে আলাদা কিছু কি আছে কিছু আছে সিঙ্গেল ডিস্ট্রিক্টটাই তো আছে ঠিকই তো আছে এই প্রত্যেকটা পিডিএফ এই তো এগুলো এডিটিং এর প্ল্যান
না আমি যেটা বলছি আছে না এটা তো
তো এই রিপোর্টটাও তো আছে এটা আর রিপোর্টটা দেখতে চেঞ্জ করুন না আপনি এটা করতে সাবমিট করেছেন সেটা দিয়ে থাকে না তো তোমরা কি এখন বলে যে চাই
এটা তো ওনারা করেছে এটাই আর যেটা এটার উপর বেস করে আমি একটা সাবমিট করেছি সেটার কথা বলছি
সেটা যাইছি না তো রিপোর্টটা জাস্ট লিখে যাইছি রিপোর্টটা লেখাই আছে
হ্যাঁ আমি তো সেটা বলছি না সব
তো সেটা আপনি বলে থাকেন কখন রিপোর্টটা চাইবেন ঠিক আছে দিয়ে দিচ্ছি। नहीं तो एवा हो गया
হ্যালো আরে টুডা লাইন প্রিলিমিনারি করা আছে রিপোর্ট রিগার্ডিং এরকম করে ডকুমেন্ট আমাকে কাল দিয়ে গেল সিসিটিভি করে দাও লার্নিং ফিডি টেস্ট নাম্বার দিয়ে বা মানে পিছন দিকে না হলে তার সঙ্গে সত্যভাবে ফিডি আমরা দেখব এর মধ্যে একটা কথা সবাই দোকান করছে Why there are no acknowledgements for justice, verify both the best solution, manage their profits and priority in further control. That's give the exceptions. Other thing, the one of the exemptions on the people. Government powers.
এখন দেখা যাচ্ছে না
আচ্ছা ভালো
এটা উনি অ্যাপ্লাই করেছেন
অর্ডারটা কিন্তু এটা কেন হয়েছে স্যার আমি ছিল না অর্ডার করেছি নকটা গেছিল খালি অর্ডারটা কিন্তু খুব ডেঞ্জারাস অর্ডার মিস্টার হচ্ছে আপনি কালেক্ট করেছেন এবং ওটা আমার দিয়ে দিন না আমি দেখুন ওটা আপনার রেজিস্টার কমপ্লিট করুন স্যার কি বলি আমার ওই এভেরিফাই করুন এটা করুন আপনি বললাম আপনার চামড়া বাঁচানোর জন্য ওটা কালেক্ট করে দিন আমরা কালেক্ট করেছিলাম কিন্তু ওই বলছে এইটা দিতে আছে তার আগে কি নেই আমার কালেক্ট করে রাখতে হবে এটা আপনার কারণ যেহেতু অর্ডারটা বলছি বলছেন তারপরে ওইটা ইমেল বললো এভাবে করে দিন ওটা দিয়ে রাখো যদি কোনো না হবে করেছি তো এই জায়গায় করেছি তো এটা হয়েছে না
একটা ব্যাপার হলো একটাও নেই কি মনে হয় দিদা হবে স্কেল আশা করা যায় রাইলে দিতেই আছে না আর তো গ্রাফিক থেকে পরে কষ্ট না ঠিক আছে আমি যদি রিপোর্টটা দিয়েছিলাম
কিছু কথা নেই আপনাকে কি বললো সেটা
আমি যেটা বলেছি যে তুই অবধি আসলে ওই ক্লিপটা নেই যেটা চাওয়া হচ্ছে
যেটা আছে সেটা কালেকশন যেটা আছে সেটা কালেকশন সিটিতে রাখুন বা যেটা করে দেওয়া চিঠি দিয়ে ওটা করুন
তাহলে এখানে তো দিয়ে দিতাম এই যে সমস্ত রিপোর্টটা পরে কি ওই সবাই খামের সাথে আপনি তো স্যার আমার দোকানে নিয়ে আসেন বুঝুন তো এই যে আপনি কি এই যে ডিজাইনটা ধরে কিন্তু মাউন্টার দিয়ে না মানে কোন জায়গায় পড়ে দিও মানে
General answer 62.
Call the list.
On the basis of joint compromise, but the town is not compromise. Who also filed Canada?
Lord, I'm for the defect of complaint.
What is the stage now? Charge sheet not submitted. What is the CRAN application? Joint compromise. Please take down. Decision application, no, sorry. This criminal revisional application has been preferred for quashing of the proceeding being GR case number 1490 of 2023 pending before the learned additional chief judicial magistrate Mathapanga, arising out of Ghoshdanga police station case number 578 of 2023 dated 15th November 2023 under section 341 stroke 376 stroke 506 of IPC. Learned counsel for the petitioner submits that this quashing application was preferred to quash the proceeding in terms of settlement, between the petitioner and the de facto complainant. An application, full stop, an application, next paragraph, an application being CRAN 1 of 2025 be placed to record the joint compromise between the parties. Full stop. Considering the situations, considering the nature and circumstances of this case, and also considering the fact that a joint compromise has been effected between the parties, it is necessary to relegate the matter before the IO as to IO who shall submit a report as to whether the joint compromise has been effected between the parties or not. Let the report be placed within a fortnight. Place the matter in the next available circuit. Not next week. How? All our matters small. I understand. The IO has to submit a report after recording evidences. I understand. Not that non-necessary. No, the petition is directed to serve upon the investigating agency through state. Serve state through additional public prosecutor. Circuit bench Jalpaiguri. Let the matter appear in the list in the next available circuit. Why not to arrest? You serve automatically, they will not arrest.
Kindly one or investigate they will only not
You serve upon the IO. You serve upon no.
Kindly otherwise
and be arrested, then will be situation is many times I was not.
No, no, I was required to take evidence and place. He is required to take down the statement of the victim and everything. Otherwise, no, no. What is the purpose? No purpose is there to serve. Yes. Next.
Oh, on petition. But in this case, the matter relates with an NI Act. If your lordship kindly take the page number 15, that is the order dated 31st January 2025. I was arrested.
Very good. Then what?
31st January 2025, I was arrested and released on bail on the ground of compromise on 4th February 2025. Now, my lord, can you see the order dated, next order dated 21st March 2025? Without any application under section 143A of NI Act, the London trial court was pleased to ask me to pay rupees 10,000 in default WA. My lord, got it?
Why payment of rupees 10,000?
That is my contention. Now, that is the next order, my lord. Next, can you see the?
Is there any direction for payment of earlier order?
My lord,
Is there any direction
no,
for payment? Then how 10,000?
the trial court so moved to pass an order directing me to pay rupees 10,000.
No, no. You read the order 20.
Can you see the order?
21st of March.
21st of March. No earlier direction was there. Suddenly an order was passed. Even regular PO has been transferred.
No, what is the order? Complainant present by filing Hajra.
Complainant is present by Khalid Sanjay, OP access files the petition placed for extension of interim bail. Regular regular PO has been transferred. 6/19/2025 for payment of 10,000 IDW. So, where and how that order was passed, I am in confusion. My lord, I am very subject to your lordship correction. I ask myself how that order has been passed.
Is there any previous order for payment like that?
No, my lord. Can you see the order? Can you see the order that is 31st January 2025? When I was arrested,
When you arrested?
I was arrested on 31st January 2025.
4th February, you were granted bail.
Yes. And then there was no order of payment. Hello. Then London trial court so moved to pass an order for payment of 10,000 IDW. Can you see the order dated 6 February 2025? How can you see the order dated 21st March 2025?
And subsequent order, that is 19th April 2025. As I did not pay the amount,
No, after the order, 4th of February, 4th of February, you have furnished the bond. Thereafter, 6th February,
I was present and paying for the extension of interim pay. And the payer was along.
petitioner raised objection.
Petitioner raised. On 24th February 2025, there was a resolution by the local court not to take any steps. And on the 21st March 2025, complaint present is filed Hajira, OP accused filed petition for extension of interim bill. Then PO has been transferred 6/19 for 2025 for payment of 10,000 IDW.
Okay.
In this context, I was subject to lordship collection in a similar situation. I will draw your question and attention when observation by the number of court and bench. Arbitrarily, that order was passed.
No,
Without
why,
assigning any reason.
why such type of order is being passed?
Being a lawyer, how can I say? Because I asked myself, but I can't get any answer.
Same order,
No.
same court.
Same code. Same code.
Please take down. Instant criminal revision has been preferred against an order dated 21st of March 2025 in connection with CR case number 424 of 2018 passed by learned Judicial Magistrate 3rd Court Jalpaiguri. Big fact of the matter is that considering the nature and impropriety of the impugned order itself, I think it necessary to dispose of the instant criminal revisional application without hearing other parties, without hearing the state court. Full stop. Brief fact of the matter is that the present petitioner arrayed as an accused of an offence under section 138/141 of Negotiable Instrument Act by a complaint lodged by the opposite party number 1. Full stop. Present petitioner was arrested in connection with the said case and was put under JC, arrested and put under JC with an order dated 31st of January 2025. Thereafter, on 4th of February 2025, he was enlarged on bail by the learned Chief Judicial Magistrate Jalpaiguri on a condition of furnishing bail interim interim bail. না তার আগে বলেছি বলে he was on interim bail, হ্যাঁ হ্যাঁ on furnishing a bail bond of rupees 1,000. The bail bond was furnished and the accused petitioner was on bail. On 6th of February, the accused was present before the learned Judicial Magistrate Third Court, Jalpaiguri, and prayed for extension of interim bail. His prayer was allowed in spite of objection raised by the petitioner. On the next day, that is on 24th of February 2025, his interim bail was again extended. On 21st March 2025, the complainant, the petitioner stroke accused person again prayed for extension of interim bail. The learned Judicial Magistrate in charge has extended the interim bail subject to payment of rupees 10,000. IDWA being agreed by and dissatisfied with the next paragraph. By being agreed by the next paragraph and dissatisfied with the said order dated 21st March 2025, the instant criminal division has been preferred. Next paragraph, learned counsel for the petitioner submits that the petitioner had no clue how the learned Judicial Magistrate has imposed an amount of rupees 10,000 upon the petitioner. It was not imposed in lieu of fine or in lieu of payment of part payment of dishonored check amount. Nothing is there.
No,
Dishon-
petition was in 143 A was there.
Okay. Full stop. Dishonored check amount. And also there is no application. No, there is no application on behalf of the complainant under section 143 of NI Act for making part payment of the dishonored check amount. It is the contention of the learned counsel for the petitioner that the learned magistrate himself on his own volition has directed the petitioner stroke accused to pay the huge amount. As the petitioner could not pay the amount on the subsequent date, that is on 19th of April 2025, warrant of arrest was issued against the accused. Having heard the learned counsel for the petitioner, also considering the order dated 21/3/2025 as well as subsequent order dated 19/4/2025, it appears to me that the learned magistrate has not assigned any reason why the payment of rupees 10,000 was directed to be made by the present petitioner stroke accused. Moreover, there are no applications on behalf of the complainant for part payment of check amount. The London magistrate has not assigned any reason for passing such order, full stop, and judicial order without assigning any reason itself a nullity, full stop. It further appears that in the similar circumstances, a cornered bench of this court in CRR 204 of 2025 has also assigned an order of London magistrate. Also assigned an order of London magistrate of similar nature. I make it clear that the impugned order dated 21/3/2025 and subsequent order dated 19/4/2025 are itself bad in law and they are liable to be set aside. Hence, both the orders in respect of payment of rupees 10,000 by the present petitioner stroke accused is hereby set aside. Full stop. Subsequent order dated 19/4/2025 regarding issuance of warrant of arrest against the accused stroke petitioner is also hereby set aside. Full stop. The petitioner is directed to appear before the learned magistrate on or before 15th of July 2025. Full stop. On such, the learned on his appearance, the learned magistrate shall proceed with the seer case strictly in accordance with the law. Full stop. Under the above mention, the instant criminal revision is disposed of. Next.
55, my lord, I am for the petition. The case related is related is a CR case. CR case filed by the petitioner, which was dismissed by the learned judicial magistrate. After that, it was the petitioner filed additional petition before the session just also upon the order. My lord, the prefect of the case.
What is the case about?
My lord, the father of the petitioner is the proprietor of AS Logistics. He has access three track on hypothecation. At the time of hypothecation, the loan, the respondent number 3 issue, credit protect insurance for the loan, for the protection of loan. My lord, after that, the father of the petitioner was died 16 July 2021. After that, he came to learn that the insurance, the credit insurance, which was issued in the name of the petitioner, the petitioner having no role in the logistic company. His father was the proprietor of the logistic company.
Whether second revision is maintainable? What is the order of first trial court? What is the order of the trial court?
Well, by Alex.
Yes. Where is the order? I couldn't find it. This is the additional district and session judges.
District and session the second court.
What is the order of JM? Judicial magistrate? Why not annexed? You annexed it. petitioner is directed to file a supplementary affidavit annexing the order of the trial court. Let the matter go out of the particular liberty mention.
This petition and praying for stay or setting aside the arrest of warrant order dated 5th of March 2025 passed by granted Judicial Magistrate Jalpaiguri. And in this matter, the petitioners were bail and the bail order is attached in lordship. But due to non-appearance from not getting the proper information from the granted advocate, he failed to appear and on that ground without giving any opportunity to the surety to inform them the warrant order was issued. I'm praying for stay or setting aside the interim order.
Yes, proceeding has already been started against the COT.
Direction is
Proceeding has already started. COT was directed. Proceeding has already started against the COT. Where are the offences? What are the offences?
under section
308, 120B,
328.
328, 120B, 308.
Some person alleged that they found these petitioners to administer some poisonous substance in a tube oil. But thereafter they were enlarged on bail. Finally, last opportunity.
Why?
As the sections were sessions travel, therefore, if I surrender before the
You have to be arrested. Why? The
again
GR case is since 2020. Now 5 years has elapsed. And it is now before the CGM. Not committed yet due to your absence. Charge sheet has been submitted already.
during the pandemic period, they have
Pandemic period is the 2020 was the pandemic period.
they lost all the connection and could not find the trace out the case number also, Lordship. Last opportunity.
Since long you are not there. Since long.
Last opportunity time.
If you got an order of stay, you will again
No, Lordship.
go away.
I will obey the order, Lordship. In any condition, Lordship. Any condition, Lordship. The layman did not know all the proceedings of the court. Did not find it out.
Since 2020, you are not appearing. After getting bail, you abscond. Never appear before the court. How can you?
Appearance was not necessary. Therefore, at that moment, we have lost all the case record and the connection. Afterwards, we tried to find out the case as it was pending before the GR office. So, case record was also not traced out by these petitioners. Last opportunity.
Other accused persons are regularly appearing. You are not appear. You have not.
Against both, three of them, what has been issued. These three of them. One has been discharged. I for two accused person. Another one. Also there. Kindly worship the.
How can it be done, madam?
7 days at least I surrender. Within 7 days I will surrender and comply all the conditions imposed upon me.
Directing the CGM to act according to the law.
Lordship, then I have to face the investigation again, Lordship, because he has no jurisdiction. Then he takes, I surrender. Lordship, in future, if they do the same thing, then condition family impose that one time, maybe. Arrest warrant. Issued.
Actually, arrest warrant has been issued, proceeding has been initiated against the COT, everything has been done correctly.
I think of one opportunity, Lord. 7 days only, 7 days. If I do this further, then
Who will responsible? Not you, not the court. No one will be responsible for that. They will again plead away.
no, Lordship.
The
7
proceeding,
days.
the sessions case could not be committed due to your absence.
Instruction. Kindly done.
Accused persons don't have the proper instruction knowledge, but they are the actual person, know everything.
In villages.
Very good.
in India.
Please take down. The Instant Criminal Division application has been preferred for setting aside an order dated 12/3/2025 passed by the learned Chief Judicial Magistrate Jalpaiguri in connection with GR case number 1458 of 2020 arising out of MAL PS case number 156/2020 dated 12/4/2020 pending before the Chief Judicial Magistrate Jalpaiguri. Full stop. Learned counsel for the petitioner submits that the present petitioners are arrayed as an accused persons in connection with the case wherein charge sheet has been submitted under section has been submitted under section 278, 284, 328, 308, 120B/34 IPC. Full stop. It is the contention of the petitioner, contention of the learned counsel for the petitioners that the present petitioners are the laymen. They have no knowledge about the proceeding of this case. Consequently, they could not appear before the learned Chief Judicial Magistrate Jalpaiguri. Vide the impugned order dated 12th of March 2025. The warrant of arrest was issued against the accused persons, stroke petitioners, for their non-appearance. It is the submission of the learned counsel for the petitioner that the petitioner may be allowed to appear before the learned Chief Judicial Magistrate. To that effect, the warrant of arrest issued against the petitioners may be set aside. He further submits that since COVID pandemic, the petitioner has lost, petitioners have lost connection with the learned advocates. Consequently, they could not able to appear before the learned Chief Judicial Magistrate. Learned counsel for the petitioner seeks leniency. Having heard the learned counsel for the petitioner, also considering the certified copy of the impugned order, it appears to me that the charge sheet of this case has been submitted in the year 2020. Since then, the case could not be committed to the Court of Sessions due to non-appearance of the present petitioner. It further appears that the learned Chief Judicial Magistrate, yes, Aste, the Chief Judicial Magistrate, after hearing the after finding that the accused persons were absent, had issued the order of warrant of arrest and also initiated the proceeding against the COT under section 446 CRPC. Considering the entire impugned order, it appears to me that the order suffers no illegality or impropriety. If the present accused persons petitioners are shown leniency, that would be the exception to the order and notion thereof. Accordingly, I find no justification to entertain the petitioners. Under the above observation, the instant criminal division is disposed of as meritless. Next.
57 my lord, I am appearing for the opposite parties, my lord. On
Petitioner
instruction
seeks
of
1 day's accommodation.
my lord, kindly direct the petitioner to serve copy upon me, my lord.
This is the motion stage.
Yes, my lord. On instruction, my lord, I have been
Now you came to
instructed
know
to
about the
appear.
matter.
My lord, my
You,
lord.
sir, you be here, madam. Let me hear about the matter. Thereafter, if necessary. Okay, come on
My
next.
lord.
Not today.
Well,
It will be fixed for hearing in the next week, and state is the only party because the complaint is the police officer. I'll get the copy served to the state in the meantime.
This is the motion stage.
Yes.
What you want?
For quashing the partial task. So for these two petitions are concerned. If I know what will please remind the last page. These the names of these two persons do not appear in the FIR. Nowhere is involved anyhow. But in the charges suddenly they never.
Very good. Please take down. Having heard the learned counsel for the petitioner. Having heard the learned counsel for the petitioner is directed to serve the application along with the connected annexures thereof upon state and file an affidavit of service on the returnable date.
Next week, Monday, Tuesday.
Next week.
7,
Not
8.
possible. This is a big matter.
Without 7 or 8 or 9.
Next circuit. Let the matter appear in the
Service upon state, my lord.
Service upon state.
Service upon state.
You serve and come.
State is already putting in appearance. We are putting in. Service code, another intervene.
Anyway, let me please then next week in the when he has already
intervened, sir.
Yes. You can
Okay. Next.
It is in Calcutta High Court that motions is applied for.
Page for quashing of the entire proceeding. Now, my lord, kindly see the page number. Annexure P1, page number 90 and onward. FIR was lost by one joint court.
There are only two petitioners, Shankar Kaur and Pinky Kaur.
Who are they?
They are the brother-in-law. I cannot say the brother-in-law. They are the brother of the deceased person with whom that the de facto complainant has relationship. Because I am saying in that fashion because my lord, can you see the page number 18? From the bottom line.
Page number 18.
Page number 18, the copy of the chart sheet. Last page of the chart sheet. And the bottom line comments from continuation of page serial number 12. Particulars of the accused person charge sheet. Now, my lord, can you see the serial number 4?
I cannot read it properly. Yes, what is this?
Miracle, who is not the petitioner here, but kindly see the wife of Ranjit Mohan Kaur. That means the lady lodged a complaint against the wife, first wife of her so-called husband. And who is the fifth? Ranbir Kaur, son of late Ranjit Mohan Kaur. Now, my lord, the most interesting thing is that can you see the page number 16 at the top? The lady lodged complaint against the brother of the deceased, wife of the deceased, brother of his wife, and his first wife and his son. Now, my lord, can you see the page number 18? Just top of the chart sheet. Page number 16. When the case was initiated, my lord, 16/11/2015, my lord. Am I right, my lord? Page number 16, the case was initiated, woman PS FIR number 192/15, dated 16/11/15. My lord, now can you see page number 30. 12. The decree passed by the learned district judge. Jayanti Pal, who represents in the FIR as Jayanti Kaur, when her divorce with one Probir Pal was dissolved, my lord, can you see on 29th January 2016, when she lodged the complaint, her previous marriage was still subsisting. Decree was passed on 29th January 2016 and the FIR was lodged on 16/11/2015. Claims herself as the wife of Ranjit Mohan Kaur, but her previous marriage was still subsisting at that relevant point of time. That is my contention, my lord. Neither she was the wife of Ranjit Mohan Kaur because her previous marriage was subsisting. Number two, She lodged the complaint against the first wife, whose marriage was still on during the lifetime of the Ranjit Mohankar and her son, along with Mr. The dates are very important, my lord. She lodged the complaint on, I'm repeating my word, she lodged the complaint on 16/11/2015. Her earlier marriage was dissolved 29th January 2016.
What about the charge sheet?
Charge sheet says, well, can you see the page number 16? Charge sheet says that the charge sheet has been filed against all affirmed and accused persons, including the present petitioners. What's the allegation in the FIR, my lord? She said she got married with Ranjit Mohan Kaur. After demise of Ranjit Mohan Kaur, she was subjected to torture committed by this petitioner, and Meera Kaur, who happens to be the wife of Ranjit Mohan Kaur, Ranavir Kaur, who happens to be the son of Ranjit Mohan Kaur, and Lavanya Prabha Kaur, who happens to be the mother of Ranjit Mohan Kaur. Just to grab some property, she lodged this false complaint before the concerned PS, and without proper investigation, the police submitted charge sheet against the first wife, son of the first wife. But the document says, my lord, prior to dissolve her previous marriage, she lost this complaint, claiming herself as the wife of Ranjit Mohan.
Okay. Yes.
Worship, such points can only be decided in course in a trial, and there is a call to go into trial, and then the disputed identity in different record call for a person trial. And
what's the wrong here said? The documents are very
Just
clear.
wait, let me hear it out.
Man,
Disturbing.
never tells.
Just wait.
not fit case for quashing and at this stage, worship.
So during investigation, what revealed? You have revealed that the accused number 4 in the complaint, Meera Kaur, Sarkar, Sami unknown, appears to be the husband of the deceased, wife of the deceased. See the charge sheet?
Page number 18 देखो. Page number 18 देखो. वो ट्रस्ट में निजी लगा और हस्बैंड नाम
Ranjit Mohan Kaur.
रंजित मोहन. Charge not friend.
Yes, also charge not from yet.
Maybe change. This go for the district. At the time of framing chair, they will. Even my lord, I'm very sorry to say, her previous marriage was still subsisting when the FIR was lost. That was dissolved on 29th January 2016. The FIR was on 15th November 2015. Iman.
Have you served upon the private?
My lord, I have served. They have appeared.
Yes.
They have appeared.
Yes, for the opposite party number 2.
My vote. Kindly one day accommodation because.
Now.
Yes,
Well, after completion of my entire submission, they are seeking 1 day accommodation.
because not filed and still I have received today.
You have appeared on the last day also. What you are saying? You have appeared on the last day also.
So 1 day accommodation.
Worship, let me file a discharge application also. Then
Why I will file discharge application? I have filed a quashing application before the honorable courts. If there is a legal impediment.
when CRBC provides for a particular remedy, the remedy under 482 CRBC may not be invoked. When law prescribes a particular course,
if he is dissatisfied with the materials collected, Lordship, he can go for a discharge application at the
Whether they
appropriate stage.
to file an application for quashing.
There are.
Huh?
Mr. Bhumik, there are.
What do you mean?
There are impediments.
So the impediment, so the impediment. So the impediment, I will reply you. So the impediment, if there is any slightest impediment.
Yes. Let me find out. What is the solution?
Our previous marriage is still subsisting. If I was not against the first wife, you are saying impediment is there.
Yes. De facto complainant. What do you want? Yes, I can give you one day accommodation, no issue. But what is the ground for one day accommodation? Have you heard the submissions of all the parties? So,
This case, I have no idea.
have you filed the Vokalatnama?
No.
Then why are you appearing? Have you instruction to appear?
Yes.
You have the instruction to appear. Now look, when the list is there for hearing of a criminal revisional application, you cannot appear and say, I don't have other instructions. Either you have to appear with instructions, unless you don't have to appear. Okay. Before High Court, you cannot say like that. So you have to say anything in this matter. I shall dispose of this matter today. If you want, I can give you half an hour time to take instruction. Okay, pass it over for half an hour. Next matter.
16.
I'm paying for adjournment for this week.
Not this week.
61.
Lord, in 61, I appear for the petitioner. May it
Yes.
please your lordship. Lord, this is an application, Lord, where we have challenged, Lord, not only a particular order, but the mode and manner of examination of the witness. My lord, on the date when the victim was supposed to be examined, my lord, the private counsel engaged by my client, the learned trial court, my lord, he retired from the brief. And my lord, what the learned trial court did, my lord, he called the legal aid defense counsel at around 12 p.m. and asked him to take over the brief and cross-examine the victim. My lord, at that point in time, the LADC requested the court for an adjournment, since taking up a brief right there and cross-examining a vital witness of the prosecution, my lord, is not favorable for the defense. So, my lord, he files an application, but that application was turned down by the learned trial court, saying that he has to proceed. Now, my lord knows the legal aid defense counsel and the system of this new system of this legal aid defense counsel, but they are under a service of the legal services authority. So, my lord, he had no option. My lord, he had proceeded with the cross examination. Now, my lord, my father and my elder brother was present in court, my lord. Later on, I got to know.
Yes.
Now, my lord, later on, I got to know that the victim was examined. I was, as per the my lord, court's order, lordship will find that I was present in the virtual mode. But my lord, the actual system in trial court, my lord, here in Jalpaiguri is, my lord, at the starting of the day, my lord, all the, my lord, the accused persons, they are produced over VC, and my lord, at the end of the day, my lord, their attendance is taken. But in actuality, my lord, these persons, my lord, they do not stay in the virtual mode when the evidence is adduced by the witnesses. So, my lord, this petitioner, my lord, my client, he was totally unaware that the victim girl had adduced evidence. He had heard nothing, he know nothing about it. But, my lord, astonishingly, in the order, lordship will find that it has been recorded that the victim has identified the accused person over virtual mode, which is not the case. So, Lord, on the earlier occasion before Honorable Justice Rao, matter was moved, and coordinate when Justice Rao had directed a report to be filed by the correctional home as well as by the learned special judge Foxo. Now, my lord, I have heard, my lord, a report has come on that might be on record, but I do not know. But we were not given any copies, so my lord, we do not know exactly what is the contents. No.
Right. Okay.
My lord, two difficulties, my lord, in the instant situation. The first is, my lord, if the victim girl, my lord, who is the star prosecution witness, my lord, if I am not provided with adequate opportunity to cross-examine the witness, my lord, my right to a fair defense is infringed. First. Second, my lord, if during the recording of the evidence, if the accused do not hear what is the nature of evidence adduced against him, my lord, he will not be able to answer that during the 313 stage. So, my lord, these two vital fundamental rights, my lord, which is a part of the right to fair trial, my lord, has been infringed in the instant case. So, our prayer, my lord, before this honorable court, that, my lord, the evidence of the victim girl, my lord, may be expunged with a direction to re-examine the victim girl upon the prosecution. And, my lord, second, my lord, since such a application has been filed before this honorable court, my lord, we, my lord, apprehend that the fair trial may not be conducive in the present court, my lord, where the trial is going. So we are also praying, my lord, that the trial may be transferred from this special POCSO court to another special POCSO court. So, my lord, these twofold grounds.
Well, it is now.
My lord, it is in Jalpaiguri special POCSO court. My lord, there is another special POCSO court in the same sessions division, my lord, in Malda. So, my lord, that is my second limb of my case. And my lord, we have also filed two PAN applications. We have also filed two PAN applications. My lord, one is for stay and another is for appointment of a special officer. Now, my lord, so far as the appointment of special officer is concerned, my lord, if lordship wishes to, my lord, dispose it off without going through that exercise, my lord.
Why special officer?
My lord, to inspect, my lord, how the VC system in the correctional home, my lord, is functioning. But I was intending to rely upon a judgment of the Honorable Supreme Court as well.
Can you provide us also? So that we can.
Yes.
My lord, that judgment is already on record, my lord. Anokhilal was the state of Madhya Pradesh, which is very relevant to the facts of the present case, my lord.
Anokhilal.
My lord found it?
Yes.
Yes, Anokhilal, my lord. Page number 27.
Paragraph 27.
Page 27, my lord. Para 20.5. Lord found it? 20.
Yes.
It says in Bashira as well as in Ambadas, making substantial progress in the matter on the very day after a counsel was engaged as amicus curiae was not accepted by this court as compliance with sufficient opportunity to the counsel. In the present case, the amicus curiae was appointed on 19/2/2013, and on the same date, the counsel was called upon to defend the accused at the stage of framing of charges. One can say with certainty that the amicus curiae did not have sufficient time to go through even the basic documents, nor the advantage of any discussion or interaction with the accused, and time to reflect over the matter. Thus, even before the amicus curiae could come to the grips of the matter, the charges were framed. The provisions concerned section 227 and 228 of the code contemplate framing of charges upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in that behalf. If the hearing for the purposes of these provisions is to be meaningful and not just a routine affair, the right under the said provisions to deny to the appellant. In our considered view, the trial court on its own ought to have adjourned the matter for some time so that the amicus curiae could have had the advantage of sufficient time to prepare the matter. The approach adopted by the trial court, in our view, may have expedited the conduct of trial, but did not further the cause of justice. Not only were the charges framed the same day, as stated above, but the trial itself was concluded within a fortnight thereafter. in the process, the assistance of the appellant was entitled to in the form of legal aid would not be real and meaningful. So, my lord, in that case, my lord, it was charges. And in the present case, my lord, it was the examination of the victim girl, my lord, which is the most crucial stage of a trial under the POCSO Act. So, my lord, under such circumstances, my lord, I am praying, my lord, that the evidence be expunged with liberty to re-examine the victim girl afresh.
Yes. For the state.
From the record, I've seen nothing as a irregularity or ambiguity. Lordship, the cross-examination completed and concluded. And moreover, your lordship, if your lordships see the cross-examinations, the conducting lawyer trying to make out a case, not that he simply stayed away, leave and nothing has been crossed. He tried to, the allegation made against the petitioner, trying to that not happen. Kindly see the cross-examination, lordship. I invite your lordships.
Certified copy page 2.
Lordships, cross-examination held on
Yes.
I cannot say the name of the Anchal. I cannot say the Anchal area and where tuition class was held. There are different teachers from. He tried to make out a case, but when he found that there is every possibility to conviction, now come with this application. Lordship, the prosecution cannot be conduct as per choice and desire of the accused. Lordships. Lordship, I don't find any illegality. Where from he got? Lordship, when he is trying to where told so trying to give some questions so that, but their specific identify everything is completed. So in a case of POCSO, Lordship, section 6, he knows that the consequences. Now he trying to file these applications, nothing only to drag the proceedings. What irregularity, ambiguity is done by the judges, I fail to understand, lordships. This is a peculiar case. Everything is completed, lordships, after conclusion, and he can recall the witness. There is another provision. If it is also depend upon the particular which questions you want to ask. So at this stage, when the case is made out, now we file these applications.
Can we see the order dated? Impugn order. There is nothing on record. My defense lawyer paid time, anything. All are verbal submission. Can we see the impugn order? Only say the accused such and such produced from JC through VC today fixed for evidence. Learned special PP and defense counsel from LDC are present. Victim girl examined and discharged. And next step fixed for nothing. He paid for accommodation. He was unprepared. Nothing. Only verbal submission. And this is the case. Teacher committed rape upon the victim girl. And for the victim girl, age of unequivocally stated all these things. They are after there is something trial court. Something happened. In a bad case, lawyer tried to give an NOC. To engage another lawyer, try to dragging the proceeding. I'm a defense lawyer, I know the proceeding. There is many instances try to drag the avoid the court something to changing lawyer. This is the another thing. After some days engaging another lawyer, I am not prepared. This is the main thing. There is my learned senior friend already stated that there is a provision for recall of the
if some any questions further once for adjudication the case to determination or adjudication, there is a provision under section 311.
Nothing on record, my lord.
But here your lordships kindly see the defense counsel trying to make out a case, make out a defense, but miserably fails to make out any defense. Now at this stage, he filed this application. This I became surprised he trying to change the entire procedure, change the law officers and the everything. So it is perfect by the
Nothing.
desire of the
judge. Most respectfully, madam.
So this is
transfer
not a
from
fit
one
case for
question.
Quashing.
There is a principal.
When there is another provisions. If you forget to take any point regarding any questions, there is a provision, my lord, you knows better than us, lordships. So
Madam, may I reply in short?
Just it.
Yes.
Yes, reply.
Yes. My lord, so my learned friend on behalf of the state has taken a point that prosecution cannot be conducted at the desire of the defense.
Yes.
My lord, very rightly said. My lord, prosecution cannot be conducted at my desire. But my lord, I am not on the part of prosecution. I am not raising any my lord, question on the prosecution. I am saying, my lord, my right to fair trial has been curtailed by whom? By the learned trial court. Milord, the learned defense counsel, Milord, the legal aid defense counsel was there. Milord, he prayed for time. Milord, any counsel, whoever it may be, Milord, if called on the spot and asked to cross-examine a witness without knowing any background of the case, Milord, it is not possible for anyone. And even if he has tried to his level best, Milord, that does not absolve my right to get a fair representation. Milord, I say that my case was not adequately represented on that very day. Milord, my points were not taken. And Milord, I have engaged a private counsel subsequently, Milord, who is competent enough, Milord, to cross-examine the victim. First. Next, Milord, my learned friend says that the witness may be recalled. Very rightly said, Milord. 311 can be invoked at any stage of the proceeding to recall the witness. But, Milord, will that wipe away the evidence already tendered by the victim girl? And if not, then, Milord, what will happen to that evidence? Because I have not heard it and I cannot respond to that under 311 CRPs. Oh, sorry, 313 CRPs. So, Milord, to that effect, Milord, this evidence will stay. And if it stays, Milord, it curtails my right under 330. Milord, these are the two submissions my learned friend for the state has raised. And I am very thankful to my learned friend for the opposite party, Milord. He has taken a very crucial point which I had missed. Milord, he says nothing on record regarding the time prayer. Milord, absolutely. This is the reason we have prayed for shifting of the trial from this court to another court. Milord, my application, not my application, the defense counsel's application, written application, but nothing on record in the order regarding the filing of that application. My lord, if this point is taken, then I pray before your lordship, before my lord decides on the application finally, let the lower court records be called. My lord, we apprehend that we will not get fair trial in that court. My lord, of defense counsel files an application praying for adjournment, there is no reflection in the order. He has refused prayer, my lord, that could have been at least reflected in the order. He did not do so. But my application is there on record. If this is the point raised, my lord, let the LCR be called, let my lord peruse the record and see, my lord, what has happened in the trial. My lord, under such circumstances, my lord, considering the gravity of the situation, my lord, I pray before your lordship, my lord, let the evidence be expunged, let it be done afresh. My lord, my private counsel is now engaged, he will cross-examine the witness.
lordship, may I? One short reply, my
Again.
lordship, lordship, my brother, after perusal the cross-examination, he ascertained that there is no scope for any further development. Now he alleging the judicial officer. I fail to understand what enmity with that petitioner and the judge. I fail to understand.
Very good. Hard. Please take down. instant criminal revision has been preferred for setting aside an order dated 34/2025 and the evidence of PW1 dated 34/2025 and transfer of the sessions within bracket POXO case 135 of 2024 arising out of Jalpaiguri police station case number 351 of 2024 dated 12/8/2024 under section 6 of POXO Act currently pending before the learned additional session judge under POXO Act comes additional session judge comes special court, additional session judge second court come special court under POXO Act, District Jalpaiguri. It is the contention of the petitioner that he was arraigned as an accused in this case. Full stop. The particular date, that is 30th of April 2025, was fixed for evidence of PW1, that is victim girl. Full stop. Learned counsel for the petitioner submits that victim stroke the petitioner produced from JC on virtual mode, and learned defense counsel prayed for time.
Petitioner stroke accused.
Stroke accused. Listens to what? Prayed for time. Learned special judge has not considered the prayer and directly appointed LADC to conduct the case in favor LADC to conduct the case.
Submission that lawyer, private lawyer given NOC, thereafter learned judge appointed LADC. His submission from the petition.
No, petitioner said there is a time petition.
Given not time petition, his lawyer given NOC, thereafter court
No, he did not.
Malad
Say. He said
refused, Malad.
one time petition is there in the record, he said. But it was not reflected in the order. This is the submission.
Yes.
Yes, কি বললাম বলো? Directly appointed one legal LADC, legal within bracket legal aid defense counsel. Legal aid defense counsel, bracket close করো. And directed him to represent the accused to cross-examine the victim girl. Full stop. It is the contents of the learned counsel for the.
Can I see paragraph 5 of the application, my lord? Can I see paragraph 5 of the application?
Now, what was submitted before this court, that is otherwise.
My lord.
Okay. কি বললাম বল? It is the submission of the learned count English বলো। কি বলেছি? লাস্টে কি বলেছিল? It is the contention of the learned counsel for the petitioner that though petitioner stroke accused was on VC, but he could not visible in the VC due to some glitch, and he was not properly identified by the victim girl. He also could not hear the statement of victim girl. By such, the fair trial is not possible, and as the instant proceeding has been initiated before this court, it is the apprehension of the petitioner stroke accused that he would not get any fair trial from the particular session judge. So he prayed for transfer of the said case to another special court under the same division. Stop. It is the further contention of the learned counsel for the petitioner that if the present petitioner be allowed to conduct the proceed with the trial, obviously he would not get any justice from the particular sessions court. Stop. He submits that the learned special judge did not allow the learned LADC some time so that the said LADC may contact with the petitioner for proper representation according to the law, for his proper representation before the sessions court. Full stop. Learned counsel appearing on behalf of the state submits that no illegality is there in the impugned order. Moreover, from the certified copy of the evidence recorded by the learned special judge, it would be revealed that there was justifiable cross-examination by the LADC who represents the petitioner, and the learned court has correctly recorded entire evidence of PW1. He further submits that this is the practice of the accused to delay the trial after ascertaining the result of the instant matter. Full stop. After ascertaining corona, after understand the result of the entire case. Full stop. After understand the fate of the case. Full stop. Learned counsel appearing on behalf of the opposite party raise strong objection. Opposite party number 2 raise strong objection and submit. Opposite one 2 stroke VG raise strong objection and submits that no illegality or impropriety is committed by the learned special court. Moreover, the LADC has been correctly appointed according to the law, and he justifiably represents the accused. Full stop. There is a full stop. Having heard the learned counsel for the parties, also considering the earlier order passed by this court, it appears that in pursuance to the order of this court, order of a coordinate bench of this court. Dated 22nd May 2025. Two reports. One from correctional home, one from superintendent correctional home, and one from the learned special judge has reached. Full stop. The report of the superintendent correctional home disclosed that under trial prisoner stroke the petitioner was produced before the learned special judge on 30th April 2025 through virtual mode in connection with sessions within bracket POCSO bracket close case number 135 of 2024 arising out of Matigada PS case number 351 of 2024. Moyanaguri, not Matigada. Moyanaguri PS case number 4. Full stop. Next paragraph. The report of the next paragraph. The report of the learned session judge has placed on record through the registry for full stop. For proper appreciation of the matter in hand, the report of the learned session judge is required to be set out. বুঝছে? এবার করবে এটা করবে সেট আউট করবে রিপোর্টটা পড়বে ঠিক আছে The report of the session judge reflected that accused petitioner was produced from correctional home through VC on 30th of April 2025 when the date was fixed for recording evidence of victim girl. When the date was fixed for recording evidence of the victim girl. Full stop. On repeated call, none appeared on behalf of the accused to take part in recording evidence of victim girl who present in court. Full stop. Finally, learned advocate verbally submitted that he would not proceed with the case further on behalf of the accused due to some hidden issue which he did not want to disclose. Finding no other alternative, learned advocate Mr. Kallol Ghosh from the panel of Legal Aid Defense Counsel System was asked to represent the accused to cross-examine the victim girl. Full stop. Mr. Kallol Ghosh requested the court for allowing him some time so that he could consult with accused in correctional home about his case to prepare line of defense during cross-examination. Accordingly, the learned court allowed him time. After 2.5 hours, the said Kallol Ghosh returned to the court and take part in the trial. The court has inquired whether the said LADC has got sufficient opportunity to discuss with the accused so that the defense of the accused can be properly elucidated before this court. On reply, the said LADC submitted that he went to the correctional home and talked with the accused, who gave him sufficient input about the case. And the LADC was ready to cross-examine the victim. It is further reported by the learned session judge that the said LADC has examined the victim girl extensively for more than 1 hour. Full stop. It was admitted by the learned session judge that though the accused petitioner was produced through VC, but all along during entire cross-examination, the online system was not connected properly due to some technical glitch. However, the lack of proper infrastructure has not disrupted the cross-examination of the victim. Moreover, the accused was properly represented through LADC and no undue advantage or disadvantage was given to any of the parties to the case. Full stop. Next paragraph. This being the report of learned session judge, it appears to me that the report of the learned session judge speaks about the proper representation of the accused person before the learned session judge at the time of cross-examination. The certified copy of cross-examination, examination in chief and cross-examination of the VG is placed with the CRR. I have perused the cross-examination conducted by the LADC. It is a detailed cross-examination, and I find that the learned LADC has conducted the cross-examination in logical manner. Full stop. I further peruse that the learned counsel for the petitioner has raised a concern about the fairness of the trial. Full stop. It appears that the Honorable Supreme Court as well as the government has provided sufficient opportunity for appointing defense counsel at the behest of the legal service authority to represent the accused person in such type of cases. Full stop. In this particular case, though a private advocate has not been appointed, but it appears that LADC has sufficiently cross-examined the victim girl. the cross-examination is more than 2 pages. Moreover, the learned special judge has certified that it takes about more than 1 hour. Full stop. The learned special judge has admitted that due to the technical glitches, the accused person was not visible during all the time. But that doesn't mean that he has denied a fair trial. Full stop. The technical glitch and poor infrastructure can be dealt with on the other manner, but that should not be the reason for transfer a sessions case from one court to another sessions court. Full stop. I further observe that the allegation against the special judge appears to me not justifiable in the eye of law. Thus, I find no justification to entertain. Under the above observation, the CRR appears to be not meritorious, and the same is disposed of. Connected applications being CRAN 1 of 2025 and CRAN 2 of 2025 are all disposed of.
May I request for consideration of the judgment cited by me in the order?
Yes. Yes, I just forgot. ওই যে learned counsel for the petitioner যেটা বলেছি তারপরে লিখবে, হ্যাঁ? learned counsel for the state বলার আগে লিখবে। In support of his contention, learned counsel for the petitioner has relied a decision of Honorable Apex Court passed in Anokhi Lal versus State of Madhya Pradesh within bracket 2019 20 SCC 196. He referred me particularly paragraph 20.5 to 20.5 to 23 of the said judgment. Full stop. Learned counsel for the petitioner further argued that the ratio laid down by the Honorable Supreme Court in Anokhi Lal is apropos applicable in this case. Stop. Last observation in considering the submission of the learned counsel regarding the proposition of law in Anokhi Lal Supra, it appears to me that in the case in Anokhi Lal, one amicus curiae was appointed and on the appointed on the stage of framing of charges. The amicus curiae had no sufficient time to go through the basic documents and not had any opportunity to discuss or interact with the accused. The amicus curiae had no clue or grasp of the matter, and the charge was framed. That practice of the court was discouraged by the Honorable Apex Court in this case. Full stop. Learned counsel of the petitioner has submits that in this case the LADC appointed on behalf of the accused had no time to interact with the accused person. Thus, accused was not properly represented.
And going through the documents.
he further submits that the LADC had no opportunity to go through the vital documents. Thus, the thus the fair trial could not be possible before the learned special. Full stop. Next, on such submission.
But I want submissions that it is not believable that the court.
I understand. On such submission of the learned counsel for the petitioner, it appears that the report of the learned special judge has specifically reflected that a sufficient opportunity and time has been given to the LADC. The LADC has given 2.5 hours time. Full stop. The LADC on query has properly discussed properly disclosed before this court, before the sessions court, that he met the accused in the correctional home and he has got sufficient input about this matter. Under these circumstances, the fact and circumstances of Anokilal is not at all applicable in this case.
Grateful.
I am for the state in this.
Which matter?
62.
Call the matter.
I'm praying for one day.
I also pray for an accommodation because in this matter, while going through the file, I realized that once back in 2021, I represented one of the accused in a bail application.
Okay.
So I am returning the writ of appointment.
Very well, very well. Come on next week. Not this week.
Smart, obliged.
Didn't I call the matter?
59.
This matter. What is this? Okay, take instruction. Yes, what is the instruction?
It's not here, Lordship.
I call him to come after half an hour.
Yes, sir.
Lordship, kindly this matter tomorrow will take it.
Please take down. Argument on behalf of the petitioner as well as the state has concluded. Learned counsel appearing on behalf of the opposite party number 2. 6 1 hour accommodation. 6 half an hour accommodation. He granted the accommodation. After half an hour, the matter was called again. None appears on behalf of the opposite party number 2. Considering the situation, let the matter be adjourned today, list the matter tomorrow under the same heading.
Yes.
Call the matter.
That was 63.
I'm for the petitioner, madam.
Lordship, I am for the estate respondent, Lordship. Lordship, I received the brief yesterday, Lordship. I need instruction.
Sufficient time. Yesterday means sufficient time.
No, Lordship, need instruction, Lordship, in this matter, Lordship.
What instruction? Let me hear out what is the case about. Then I will ask you what instruction you need. Yes.
My lord, petitioner pays for the issuance of license, fair shop license, my lord. One notification dated 6/5/2024 was issued at Malbazar. After that, petitioner applied for the vacancy, fair shop vacancy. Then there was a personal call for personal interview, but till date they did not issue any license, my lord.
After the interview, my lord, and after submission of all the relevant documents, on the portal, it shows that my application was approved. But after approval, my lord, I went to the office of the concerned office, but till date, they are not issuing me the license. On that grievance, my lord, this application has been filed. My lord, text of this page 19 and it's a P4. Current status approved.
Have you made any representation?
No, my lord.
So directly
I'm
come to
afraid-
this court.
My lord, let this application be considered as a representation.
Is it?
Because this
Court
application.
is the place to file representation.
No, my lord.
Then?
Let this application be referred to as a representation.
Why? Yes. What is your instruction?
So
What is the stage? What is the stage?
I have to take instruction, Lordship, that
Come tomorrow with instruction.
Lordship, day after tomorrow, Lordship.
Not day after tomorrow. You take instruction verbally.
Lordship.
I want to know what is the stage. Okay?
Lordship.
Do you want any order?
Lordship.
Please take down.
My lord,
Petitioner is an applicant for concerned FPS dealership. After submission of application, his proposed shop-cum godown was inspected. He was called for personal interview by the district level fair price shop selection committee. On portal maintained by the department, it appears that the name of the petitioner was marked as approved. Approved.
Well, but after filing of this petition, what came to my knowledge is that similar batch of applications are pending, my lord, due to one MAC Win 1543 is pending before the principal bench for consideration. In that MAC, my lord, there is a stay over all this, the issuance of license.
Has they disclosed it before you?
No, but they have not disclosed, but
Then
I have come to know from this order, my lord. If my lord goes to this order for once.
paragraph 10 of that order.
Yes, my lord.
Then
So
I
they
know
have
that.
filed an affidavit and disclosed it.
Not affidavit, not required to file affidavit. Yes. Was marked approved. Approved. Hence, this petitioner approached this court for relief. Full stop. Learned counsel appearing on behalf of the state seeks accommodation proof. Accommodation for want of instruction. Let the matter appear tomorrow. The learned counsel for the state is directed to apprise this court regarding the stage of the impugned notification. Let the matters come and let the matter appear in the list under the same header tomorrow.
Good. Develop.
Yes, next.
64.
I'm for this statement.
Lordship, I'm for the petitioners. Fair price shop. Lordship, before Lordship sees the earlier orders and directions, May I place the case of my case in a nutshell?
Yes.
Lordship, kindly see page 19 of my petition, main petition. That is the first fair price shop license which was issued by the government of West Bengal. The name logically says Messrs. Guho Enterprise Partners, 3 partners, one Parul Rani Guho, Oshit Guho, and Shamul Guho.
Yes.
Page 19. The place of the business is village Dokhin Patkapada. This is relevant, Lordship. This was issued in the year 2001. What is, Lordship? Page 19.
Yes.
So the place is Patkapada. The concern name is Messrs. Guho Enterprise, and partners are Parul Rani Guho, Oshit Guho, and Shamul Guho. Now, Lordship turns to page 20. This is the agreement, the first agreement between the 3 partners. Actually, Parul Rani Guho is the mother of the Oshit Guho and Shamul Guho, the mother agreement. Subsequently, Lordship will find that the Parul Rani Guho dies. Lordship, we have filed it in page 25, the death certificate. She died on 14/6/2004. Then, Lordship, page 27, this Guho 26, Lordship, Guho Enterprise. Subsequently, after the death of Parul Rani, it was the partnership business. The license was issued in the name of Oshit Varan Guho and Shamul Guho, the two sons, who stepped into the shoe of their mother and became the partners. Subsequently, Lordship, once again, as ill luck would have, in 27 and page 29, Lordship will find the Oshit Varan Guho and the Shamul Guho both expired. Both dies. And in page 28, Lordship will find the legal heir successors name. That is the writ petitioners, Nanda Guho, Rajdeep Guho for one, and Ankita Raha, that is the daughter of another. Legal heir. Now, Lordship, these 2 persons, the writ petitioner, being the legal heir of their father and husband, they applied for license. The license was not, their prayer was rejected. On this ground, we have come here. Now, Lordship, kindly sees order dated 16/12/2024. First order.
Page.
Lordship, order of the court, Lordship.
Order of the court.
First order, 16/12/2024.
This is motion stage, I think.
No, Lordship, the exchange of evidence
For hearing.
Okay.
This is coming under motion.
No, my lord, not hearing. Affidavit for the exchange. Only the report has been exchanged.
Supplementary affidavit has been given.
Supplementary affidavit,
Report.
not oppositions.
They have appeared and hearing.
Yes, what order?
My lord,
16/12/2024, and this is regarding affidavit of service. Then 3rd January 2025, a report was filed by the state.
Yes.
Supplementary affidavit, our prayer was allowed. On 7 January 2025, next order, we have filed the supplementary affidavit along with certain documents. And court was pleased to sort a report from the state regarding veracity of those documents. 7 January 2025.
Yes.
Now, on 6 March 2025, a report was filed by the state. Copy has been given to us. Take the front of the book.
report dated 5th of March
5th March 2025. What is your shape?
Yes.
Now, from this report, sir, this report is nothing but reproduction of the earlier report, first report. Now, the order was given regarding veracity of our document. But what the report says, if Lordship kindly sees, is not paginated, but if Lordship kindly sees the report.
Report dated, my lord, 5th of March.
March 2025.
Yes.
Got it, Lordship? What is lordship? If lordship turns one page, the brief history regarding WPA has been given by the state. What is lordship? Kindly see lordship the last line. Yes, on compassionate ground, license can be issued only to the family members as mentioned in such and such notification is there. What is lordship?
Yes.
Now, family members means the next page lordship. It has been explained by the state. We are grateful to the state. Roman 1, spouse. Now, lordship, one of the writ petitioner is the wife of late husband who was the licensee of that thing. Another 4 daughter, including daughter legally adopted and such as who is only dependent. Now, another writ petitioner, second writ petitioner is a daughter of another licensee. Now, whether they are dependent or not, from the report I will show. Now, kindly see number 2, the fair price shop was done in a hard plot land. So, the earlier license, since inception, the fair price shop was run on a hard plot land. Because the Patkapada Gram Panchayat, where the shop was established, belongs to a hard plot land. Now, lordship, the second document is our document, Audit Boron and Shamal's death certificate. Now the application which the writ petitioners have.
You forget to state point 3
Which one?
of that report, page 2.
At present, yes. At present, the ration shop is currently tagged with Krishna Guho, I have such and such, Paschim Shalbari, Alipurduar. So, as because the license was not issued in the name of the writ petitioner, but the writ petitioners are carrying on business, the business has been tagged with another fair price shop. So that the public in general they get the service from the fair price shop. Next, lordship, the inquiry report which has been submitted by the state. Kindly turns to lordship.
Now, how you aggrieved? Whether any order is there by the authority?
Lordship, yes, lordship, I will come to that. Kindly wait for a minute.
Yes.
Lordship, I don't know what is the page number. It's mentioned 54 in the top. Lordship, the inquiry report. Analysis. Name of the part A, date of inspection, so on and so forth. It is not page
8. Page 8.
Page 8.
Yes.
In
Page
that
8.
report.
In our. Lordship, page 8 analysis.
In that report.
Yes, in the report dated
In the
5th
report,
of March.
report, page 8. What is lordship? Now, kindly lordship, number 1, name of the applicants, the writ petitioners' names are there. Now, number 5, relationships are mentioned, lordship. Analysis, wife and something. Yes, okay. Now, lordship, 12. Whether the applicant has any other means of substance? No. So, they are dependent, lordship. 13. Employment status of the applicant? Unemployed. Now, 16. Whether engaged in any other trade business? No. 17. Whether the applicant submits no objection from family members? Yes. So, other family members issued no objection. Whether photocopy of death certificate of the dealer? Yes. Now, most importantly. 19. Document supported? Yes. Now, 21 is most important, lordship. Whether any proceeding initiated? No. Details of the shop come go down. Part B. Address of the shop come go down. Village and post Patkapada. Nature of possession? Rental. Third, whether the place of business of the applicant is located at the same place of business of the deceased informed dealer? Yes. So, at present, we are running the business from the same premises where our father and husband were running the business, and prior to that, the two son and grandmother were running the business. Same place. Now, Lordship, satisfactory report. Yes, the proposal such and such conditions is satisfactory. Now, Lordship, the next page. Rejection of our application. Why? On what ground? Conditions Mrs. May I read, Lordship? Mrs. Go Enterprise, Nanda Go and Srimati are partners, as they could not produce requisite document, that is valid license on behalf of the partnership firm, documents regarding possessional right of the proposed Topcom godown, and old partnership deed. Now kindly see, Lordship, our page 20 of our writ petition, the old partnership deed is there.
Have you produced it?
Yes, Lordship, we have sent it to them. We have by virtue of supplementary affidavit we have given.
No, you have submitted before the authority.
Yes, I'm coming to that. I'm coming to
Where
that. I'm coming to that. Kindly see, Lordship, our representation. Page 62, along with all annexed.
Page
62 representation.
My lord, kindly see the date. 18th of September 2024 and the rejection order is of the year 2022. How it is proved that they have submitted at that time in the year 2022? Show me some document which can prove that it was submitted in the year 2022.
2022. Lordship, kindly sees it again. Order dated 19/4/2023. Your document 19/4/2023. The rejection. Can you see, Lordship, page koto? 19/4/2023.
Page 14, man.
Page 14. Can you see the grounds? Number one, got it, Lordship? Number one, it is emanated from the license copy under WBPDS order dated 2003, which was renewed up to 1/1/2010. That the license was Sri Ashit Boron Guho and Sri Shamal Guho. On the other hand, old partnership deed shows that the names of three partners, that is Parul Guho, Boron Guho, and Shamal Guho. I pause for a moment. At first, they are saying the old partnership deed was not, we did not submit. Now they say the old partnership deed has three names. How could they say the same if those were not supplied to them? Now, Lordship. So submit the actual partnership deed on basis of which the FPS license was issued. The FPS license was issued by the same partnership where the three names were there. The first Parul Guho, Ashit Guho, and Shamal Guho. It is within the clutch of the department. They got the names of them also. By virtue of this, by using that deed, they have issued the license in the name of those three persons. Subsequently, after the death of Parul Guho, the license was issued in the name of her two sons. The documents are with them. Now, Lordship, so submit the partnership license was issued. Proper documents regarding possessional right of the application. The inquiry report says the house where we are running the business, same premises where the license two times the license was issued. How can it be? They don't have the documents. How they issued the license? Lordship knows better than me the 106 Evidence Act. Special knowledge. If they don't have the documents, how they issued two times the license? It is only for the purpose, Lordship, so that our license is not issued and it can be sold to some other persons.
No, what is the issue? 2022, one order of rejection was passed by the deputy director.
23, Lordship. This is order relation 23, 19 for 2023.
27th of June 2022, you show me the order.
The previous one, yes. Yes,
The
sir.
deputy director has rejected.
22. Yes, Lordship.
Rejected.
Lordship, now grounds for non-supplier, valid license on behalf of the partnership firm, documents, we have the partnership firm valid license, it is issued by them.
No, let me understand.
Lordship.
So 2022, the deputy director has passed the direction to the district controller
Lordship.
to resultant vacancy
Lordship.
as because the your rejection of your application. So why 2023 again consideration?
Because Lordship, we have given the documents. Once again, consideration was failed.
Regarding submission of requisite documents.
Lordship, we have given the documents. Same thing, once again.
For reconstruction. Compassionate ground. Oh, thereafter they again started for reconstruction.
Document they are asking. We are once again they are submitting and same document they are asking.
2023 April, they have proper document regarding.
Lordship.
And August 2003, there is rejection, order of rejection.
Lordship.
So what you challenge here?
Which challenge the last one? That 19/4/2023.
19/4/2023 and the order dated 1st August
Lordship.
2023.
Lordship.
Rejection.
Now, 1st August the order. Kali says there is no endorsement of receipt. But if we take it to be granted that yes,
This is the intimation.
it was communicated. There is no endorsement because as per our information, it was not supplied. But same thing logically is old partnership or document regarding professional. It is with them because they have issued the license. Without getting the partnership, how would they issue the license? In the name of my grandmother and my father and my uncle. Subsequently, my father and my uncle. And after their death, we have applied for our. Documents are with them. Originalities are with them. How can we submit the originality?
Now what is page 15?
Page 15
After the order dated, what you challenge after that?
This is the data given by this petitioner's matter.
2023. After you order, you challenge.
Lordship. অসিত পারুল গুহর পুরনো পার্টনারশিপ দলিলটি আমার বাড়িতে অনেক originally name lordship because after receiving the original deed the license was issued. Now these two rustic lady, how can they don't know
Yes, next second point.
দলিলটি আমার বাড়িতে করেছি পাওয়া যায়নি তার কারণ আপনার কাছে এইটি প্রদান করতে পারি নাই রেশন দোকানের সঠিক জায়গা দলিল পর্চায় রেকর্ড প্রদান করতে পারি নাই how can because it's a hard land how can I get the deed and ROR in my name because when the license was issued in the name of my grandmother and my father and it was hard land because the inquiry report says same place. When the license was issued in the name of my father and uncle, it was the same premises. Land?
No, I could not understand. There must have a license.
License, yeah.
Must have a license in favor of you in a land where you are running the business. Is there any document you running the business? Is there a document you where are you running the business?
Page 17.
Over the land of others?
No, my license in the name of Quashing Supplementary affidavit, page 17. 17 onwards. Jalpaiguri Jila Porishod অধীনে হাটের জমিতে লাইসেন্সের জন্য আবেদনপত্র অসিতকরণ গুহ। Next is form of license shopkeeper অসিতকরণ গুহ। Analysis license. Then গ্রাম পঞ্চায়েত অসিতকরণ গুহ tax paying খাজনা. Then lordship MR enterprise all called khazana documents are there. Electricity bill is also there.
So in the name of whom?
Firstly, Ashok Baran Guho, kindly see page 25. Nanda Guho, wife of late Ashok Baran Guho, that is one of the petitioners. Page 25. Now she is giving the khazana. Possession document. Page 26, electricity in the name of my late husband, Atit Baran Guho. Page 27, same thing. Even October 24 to December 24. Latest bill we are giving. Then says Lordship. Positional document. What else can I show? Because the license is in the name of the husband of one of the rate petitioners. And on the same hard plot land, Lordship, earlier 2 licenses were issued. And now they want deed, ROR, because it's a hard plot land. How can we get to the deed in our name?
Okay, it's a license from the government upon the shopkeepers.
Shopkeeper.
So license was issued in favor of Asit Baran
Atit
Guho.
Baran Guho.
So after demise of Asit Guho,
We have applied.
and you have received the license?
No, this has not been as because this thing is going on. So they have restrained the authority to issue the license. That is the reason.
They have restrained the authorities. How the separate authorities?
Lordship knows that there's a government who are working and for what?
Now, whether you are possessing now?
Yes, Lordship. It is on their report.
No,
Inquiry report. Inquiry report. Their document, Lordship. What noise? Alice is the inquiry report, Lordship.
Who is giving the tax now?
One of the rate petitioner, Nanda Guho, wife of Asit Baran Guho.
Okay, I understand.
The report, if my lord allows me, some document I would
Let him
like.
finish, let him finish.
Oh, my lord.
Lordship, that their inquiry report, point 3, whether the place of business of the appellant is located at the same place of business of the deceased. Yes, the same place of business.
And by supplementary, you have placed those documents.
Lordship. Because my transfer I really appreciate. In a hard plot land, India 2001, the license was issued in the name of my grandmother, my father, and my uncle. After the demise of the grandmother, license on the same premises was issued in the name of my father and uncle. After their death, my aunt Nanda Guho and me, being the daughter, we have applied. But our license was not granted. But for the smooth distribution of the service to the public, our ration was attached to another, so that the flow comes. So that the flow comes. And they have rejected. We have applied once again with the documents. They have received the documents and they are saying now this thing.
What is the partnership document between the rate petitioners?
Our partnership.
Have you placed this?
Yes, Lordship. Lordship, page 34.
Rate petition.
Our rate petition.
Okay.
And page 20 is the first partnership between my grandmother, my father, and my uncle.
Yes, for the state.
My lord, it comes to page 15 of the report dated 5th of March 2025. Page 50, my lord. The document submitted by the petitioner, the letter written by the petitioner. In this letter, what Mr. Ganguly has stated just a few minutes back, that the original copy lying with the state, has they mentioned it in their letter? The copy lying originally with you. We don't have the copy. Nowhere it is written. First. Second, my lord, if my lord comes to page 16 of the said report, my lord. It is the fresh inquiry conducted by Sub-Inspector Food and Supply, Alipurduar 1. It is clearly stated here that in persons of the above said subject and memo number such and such, this is to inform you that Srimati Ankita Guha Raha and Srimati Nanda Guha is not now in position to submit the requisite documents, that is the old partnership deed and land documents. So the application for new license may be rejected and the result vacancy may be initiated. Now, my lord, what he submitted, page 20 in his writ petition, the partnership deed, the old partnership deed. Kindly see the partners, name of the partners. First, Parul Guho, second, Osit Borman, third, Samuel
Borman Guho.
Oh, sorry, my lord. Osit Borman Guho and Boron. এখানে বর্মন লেখা আছে।
এটা হাতের লেখা, পরেরটা উল্টো দেখো ওখানে ভেতরে টাইপই আছে।
তবে তো ফার্স্ট পেজ দিয়ে এটা বুঝছি না। And the third one is, my lord, Samuel Kumar Guho. Now, the license, if we consider this as the old partnership deed, then the license might have been issued on these three names or any one of them. Any one of them. But the license which was they have given in their the copy of the license, there has only two names.
No, three names. Page 19. Go through it.
But in our
Writ petition. 2001.
Come on tomorrow.
My lord,
Out of time.
Page.
That was subsequently after the death of grandmother. There will be name of the father and
Tomorrow.
Hello.
Continue.
Hello.